Good morning and welcome back to the second day of Bucharest Arbitration Days 2022. Our first panel today covers energy projects and investment disputes. We are going to have an entire morning dedicated to investment arbitration. Now, coming back to this panel, it is difficult and inappropriate to try to suggest a hierarchy or anything like this amongst the close to perfection panels that cover the topics of Bucharest Arbitration Days, but you are going to agree with me soon that we have a perfect lineup of speakers, that we have a always attractive topic, which is investment disputes related to energy projects. I would even say explosive these days. Obviously, you are going to witness that we have a perfect gender parity. We go even beyond this point in terms of parity, is a panel with perfect parity between on-site and remote speakers, which is, again, close to perfection. Our panel is, long story short, almost perfect, and not perfect because the only thing that can be improved is the moderator, but this is something can be easily overcome. And now, with your permission, I will briefly introduce the speakers. Ladies go first, and Silvia Tonova, on my right, is a partner with Jones Day based in London. She has a particular focus on disputes between foreign investors and governments. She acts both as counsel and arbitrator. She is appointed in the International Center for Settlement of Investor Disputes panel of arbitrators. She has geographically wide experience in Europe, Middle East, Africa, and some other jurisdictions. She worked a lot in mining, oil, and gas energy. She is also co-chair of the International Commercial Arbitration Case Law Subcommittee within the International Bar Association Arbitration Committee, and she teaches investment treaty arbitration procedure and enforcement of awards at Roma Trade Law School. Welcome, Silvia. Our next lady speaker is Sabine Conrad. She is based in Frankfurt, Germany. She is partner with Morgan Lewis. Sabine focuses on international dispute resolution with a special emphasis on investment arbitration and international commercial arbitration. She has broad experience in a range of industries, including energy infrastructures. She has represented many clients in Europe, Middle East, Africa, Latin America, and Asia. She also acts as arbitrator in investment treaty arbitration and international commercial arbitration cases. And obviously, she is a very experienced counsel in the said type of projects. Welcome, Sabine. Now, moving on with the gentleman, we have Luc Sobota, and we were kidding a little bit earlier, but because it is important for everybody to know that he is actually a hero. Luc, who is partner with Three Crowns and based in Washington, he is, as we speak now, remote, you can see him, on the East Coast, which means 3 a.m. in the morning, and he made this tremendous effort to be with us and with you today. Special thanks, Luc, for this. And now, brief presentation. Luc is has a tremendous experience in interstate arbitration, including he has all sorts of records, such as one of the largest publicly reported ICC cases in history. He is he has an impressive academic experience. He is senior lecturer at Harvard Law School and adjunct professor at the University of Miami Law School. He is praised, among many other ways, as extraordinarily intelligent. Welcome, Luc, and happy to have you on board. Last but not least, we have Baiju Vasani, who is, as we speak now, an independent arbitrator based in London. He used to split his time between Moscow and London. Previously, he has been a partner and led the international arbitration practice with Jones Day. He also teaches international arbitration at the University of London. He's a very experienced arbitrator. As of September, this is not a secret, it is publicly announced that he accepted an offer of tenancy with 20 Essex. So I could say, and I hope I'm not wrong, that this is the first public speaking engagement with Baiju as future member of 20 Essex Court. And now I feel obliged to provide to Baiju a bonus because he got to be introduced last as a gentleman staying next to me. But this is something you are all going to enjoy, something that the peers and our clients said about him. I quote, "Baiju is a storyteller to whom you could endlessly listen to, feeling convinced the story is as accurate of a description of the dispute as could be." So I'm very happy to hear the story that we are going to hear from Baiju and the rest of the speakers. And now, last introductory remark about the topic. We are supposed to discuss in slightly over 1 hour about energy project and investment disputes. Obviously, this is a topic that cannot be covered, will never end, and so on and so forth. What we did was to choose the following approach. Since we all discussed recently about the 360 degrees camera, those smart cameras that are supposed to cover the witness that is cross-examined remotely, and we tried to use a 360 degrees camera and we looked at the investment disputes in the energy field, and we sort of cherry-picked those legal issues that we deem to be of utmost interest. And the outcome is that we are going to discuss about the relationship between green transition and the ISDS. Then we are going to discuss about regulatory instability in the energy sector with a special view upon Romania and obviously its impact on investment arbitration. Then we are going to discuss about sanctions and their impact upon energy industry. And last but not least, because we have to discuss also about money, we have chosen financing instruments as investments in the energy sector. Without further ado, Sylvia, you go first, and let's see what kind of love and hate relationship we have between the green transition as a whole and the ISDS. The floor is yours.
Thank you, Cosmin. It's absolutely a pleasure to be here. I love coming back to your city. For those of you who are from Romania and from Bucharest, I am originally south of the border from Bulgaria, so it does very much feel like coming almost home every time I'm in Bucharest. The other thing that I think Cosmin failed to mention is to properly introduce this panel as the Jones Day panel almost. Apologies, Sabine, because not only am I currently at Jones Day, but Baiju was formerly with Jones Day not too long ago, and so was Luke. So may I add that to the introduction. On to the topic for today's discussion. I think there's been much discussion, at least in certain circles, about the potential of investment treaties and investor-state dispute settlement generally to undermine the transition to clean energy and climate change. How, you might ask? Some would argue by creating a disincentive for states to pass bold energy transition measures, or what's been called, I think, in the media or in some circles as a regulatory chill. I would submit to you that the answer perhaps is not as simple, and I think simplification of these important issues doesn't serve anyone. I think in this context, when you have states taking measures to combat climate change, a necessary question often arises of who should bear the losses, right, from the phasing out of sort of conventional energy sources. Is it the investor whose assets run the risk of being stranded, or is it the state which may be under budgetary constraints? So it's a very important and delicate balance that needs to be struck. Another thing, just by way of introductory remarks, is that you would know, and I'm sure most of you would know, that just because you have a public purpose to do something as a state, right, because you're doing something to address climate change or the climate crisis, which we all agree is a very laudable goal, that in and of itself does not amount to a reason to make the investors pick up the tab, right, and pay for it. And this is just a basic tenet of investment protection law. If you look at the vast majority of bilateral and multilateral investment treaties, they basically provide that, yes, you can expropriate as the state, but you must provide compensation, right? You can take for a public purpose, you can take property for a public purpose, but you must provide compensation. So as climate change and energy transition plays an increasingly important role in the decision-making of both private parties and government entities, I think one issue is bound to come to focus, and that's the issue that I will focus on in this debate. Is there a potential conflict between, on the one hand, a state's international environmental law obligations under the Paris Agreement or other climate change treaties, on the one hand, and its obligations in investment treaties as such, because many of the states have obviously, signed up to both of these sort of sets of treaties, Romania, by the way, included. So first, I'm just going to go over at a very high level, because I'm not an environmental law lawyer by any means, of sort of the climate change treaties that at least I'm aware of, and I'm curious if you're aware of any others. But very briefly, you have the UN Framework Convention on Climate Change from '92. That one is interesting because it's almost universally sort of adopted and ratified, but it doesn't have many teeth really, because the signatories only agreed to aim to stabilize greenhouse gas emissions, but set no obligations or specific targets. Then you fast forward to 2015, you have the Paris Agreement, adopted by roughly the same countries, representing over 98% of the world's emissions. And it was that first agreement to set a specific goal to limit global warming to below 2 degrees Celsius compared to pre-industrial levels, and to require countries to implement certain measures to this effect. And Romania, as you probably know, as a signatory, and it has ratified the Paris Agreement. Then you fast forward again to only last year, to the Glasgow Climate Pact, COP26, that was adopted and ratified by largely the same countries. And the signatories there committed to accelerate efforts towards the phase down of unabated coal power, and then the phase out of inefficient fossil fuel subsidies, and to revisit emission reduction plans in 2022, in other words, this year. So you have these sets of commitments on the one hand, and then on the other hand, you have more than 3,000 investment treaties concluded by these very same governments, very same states, that provide foreign investors with investment protections under international law. Many of you who practice in this area or sort of slightly familiar with it, you'd know that you have not only your protection against unlawful expropriation, but fair and equitable treatment and other sorts of wonderful protections. So as such, some have argued that there may be a potential conflict, right, at least on its face, between, on the one hand, a state's obligations under the Paris Agreement to reduce greenhouse gas emissions, and their obligations under investment treaties to protect the legitimate expectations of foreign investors, which would include many fossil fuel companies, obviously. So some, just going now to the issue of, is there actually a conflict, right? Or is it a false conflict? And I'm curious to hear the views of those of you in the room, if you have any later on. But some treaties have obviously dealt with this issue preemptively, and they've addressed the regulation of the environment in the text of the treaty. In Romania, at least, I know that Romania-Canada bilateral investment treaty contains an exception for environment and public health. So maybe with these treaties, it's an easier interpretation issues. But of course, as many of you know, not many of these treaties contain these types of exceptions. So then the question becomes, how do you sort of interpret these sort of arguably competing obligations? So I'm going to pick on the Energy Charter Treaty because it's one that I think, first of all, there are lots of cases under it, and it's sort of a good poster child for this sort of issue because it deals with energy, obviously. The ECT, as it's commonly known, was ratified by the signatories of the Paris Agreement and the members of the UNFCCC. And then one would say, or could say, that on the one hand, they have the obligation under the ECT to protect all investments, including those in the coal, oil, natural gas sectors, and then they have to meet their climate change obligations. So reaching these targets under climate change treaties, scientists have said, will require steep reductions in greenhouse gases, unprecedented overhaul of energy systems, including the phasing out of fossil-based energy sources. So how do you reconcile all of these treaties? So no provision in the ECT necessarily sort of tells you how to do it, but we'll get to that point in a second. If you look at the available Energy Charter Treaty awards, of which there are probably over 60, at least to date, none of them has exactly dealt with an issue where an investor has challenged a measure of the government taken for purposes of climate sort of action or energy transition. I know you'll hear from Luke about all the sort of renewable energy sort of cases, but I would suggest that these are somewhat different, and we can talk about that more in the discussions. There have been at least a couple of cases, though, filed arising out of climate sort of change measures by the governments, and that's two cases against the Netherlands filed by German companies RWE and Uniper. Both of these are challenging a 2019 law that phased out coal plants by 2030, and this law was enacted precisely for the reason of meeting the Netherlands' commitments under the Paris Agreement, and both investors obviously claim that this law does not provide adequate compensation to phase out or transition their fossil fuel reliant plants, and they say that's an expropriation. So these are very interesting cases to watch in this space. The Netherlands has raised defenses based on climate law, including the Paris Agreement. So what do you do if you are a tribunal sitting on these, cases? Let's say you have to interpret the Energy Charter Treaty, and you're faced with sort of these, arguably competing sort of obligations. So luckily, the ECT has a provision, Article 26, which requires tribunals to decide an investor-state dispute in accordance with the ECT. And then it says in accordance with applicable rules and principles of international law. So you could take a view, if you are a member of the tribunal, that applicable rules and principles of international law may include the state's obligations under these climate change and environmental treaties, and even obligations under customary international law. Article 16 of the ECT makes it, I think, easier for the tribunals when it comes to this interpretive issue, because it basically says that if there is a conflict between the ECT and a provision of another treaty, then the treaty more favorable to the investor will prevail, right? So that's one provision of the ECT that I think arguably makes it easier for tribunals to deal with this issue. But you would know that, not many of other treaties contain a similar provision, right? So in some treaties, in the absence of this provision that actually deals with a conflict of international obligations, then you as a tribunal member or as a council, you have to argue the position of whether a national environmental measure that was implemented under the Paris Agreement can trump investment protections contained in other treaties. And here really you have a couple of options with which I would conclude my remarks. Sort of, they're not really rocket science, but just to put it out there, you could try and interpret, the Paris Agreement obligations or any other obligations consistently, right, with your existing treaty. And some would say, well, this is what the Vienna Convention on the Law of Treaties requires you to do. If you cannot harmonize the two treaties, then you need to take a position on which one prevails. And here, I haven't found a case that's dealt exactly with a conflict between sort of a climate-related sort of international obligation and investment treaty law, but you could look at the numerous examples where tribunals have had to interpret EU law on the one hand, and the Energy Charter Treaty or another investment treaty for that matter. So in only one case that I've been able to find, Electrobel versus Hungary, did the tribunal say that EU law trumped the ECT. Most of the tribunals have said that where there's an inconsistency between EU law and, let's say, the provisions of the Energy Charter Treaty, the Energy Charter Treaty protections prevail. And a final sort of perhaps an easier and less controversial way for you to sort of argue your case if you're counsel or if you're sitting as an arbitrator is to say, you know what, these international EU climate law obligations, I'm going to treat them as a fact, right? I'm not going to say they're sort of the, you know, supplying the governing law of or whatever dispute I need to decide, but I'm just going to treat them as a fact that goes to whether the state was rational, reasonable, arbitrary and transparent in enacting the government measure. And for instance, let's say if a state has phased out a, you know, fossil fuel plant, then you would analyze whether doing so pursuant to certain international EU climate law obligations, how that sort of goes to the reasonables of its actions in meeting its obligations under the investment treaty. So these are at least some of the, I've just canvassed very briefly, at least some of the possibilities of how international climate treaty obligations on the one hand can interact with investment treaty obligations. But let me just go back in conclusion to the concept of I started with, and that is that of the regulatory chill, right? Like everybody's talking about states, being, afraid to act to combat climate change because of this perceived tension between climate change obligations and then investment treaty obligations. I'd say very humbly, and I'm curious to hear other views, that you can't really generalize. This is, as Cosmin said, complex issues, right, in investment treaty disputes. This is the name of our panel. It is really not that simple in this space, and you really have to look at the language of the treaties in question. You have to look at sort of the nature and the scope of the government measure and take it from there. But one thing I think is clear, treaties will have an increasing impact on industries affected by climate change and energy transition. So with that, let me turn over back to you, Cosmin.
Thank you. Now, if there are any questions from the floor, we can take them. Otherwise, I have one, and obviously the other speakers are free to raise a hand physically or digitally and inform us whether they want to comment. My only question, please, Sabine, the floor is yours.
You go first. I was just indicating an interest to chip in afterwards, but you go first, Cosmin.
Okay, so it's sort of brief and I hope not a philosophical question. I would say that there is, I don't know, at least a tension between whatever green transition means and generates in terms of obligations and the investors' rights and legitimate expectations. They overlap to a certain extent. My next sort of remark is that in the current context, which means that in the entire Europe it has become an important immediate goal to gain independence from Russia and all its resources, I would expect a sort of rearrangement both of the what EU called the clean energy and emission reduction policy, as well perhaps of the green transition commitments and the general framework. And in my view, it should make sense, or it would be logical for these tensions to actually alleviate in the immediate context, because something else has become more important, at least as an immediate target. Am I right, or is it just a hopeful, naive hope coming from me? Thank you.
Cosmin, I will never say you're naive. Okay, no, you're not naive. No, I think your insight is spot on. I think you have to take into account the realpolitik, right, of the world we live in and sort of the tensions. And to be honest, I used to represent governments at my prior firm. It's just sort of the demands on and sort of the competing sort of priorities that governments are faced with. So I think for the purposes of bringing this back to the context of an investment treaty dispute, every dispute is sort of decided so much on its facts, right? And when you talk even about legitimate expectations, you talk about legitimate expectations not actually on a very long spectrum of time, at the time the investor made the investment, right? So that is the key sort of temporal element, you know, if you want to focus on that particular type of claim, which is the fair and equitable treatment, legitimate expectations claim. So I think my answer to B would be not very satisfactory, I'm afraid, which would be it depends, right? So there are these sort of, you know, tensions, but again, in the context of a specific dispute, it depends. The investor's expectations and how we analyze them depend really on the time at which the investment was made, the types of sort of commitments or assurances or you know, it relied upon from the government. So it's a complicated question, as you state.
Thank you. Sabine, your comment, please. Then we can move on to the next topic.
Yeah, no, as someone who has spent, I think, the last 10 years or so on an investment arbitration concerning the phase out of an entire energy form in Germany, I can tell you that change is always hard. But let me start with something provocative first. The climate change or the international efforts to stop climate change, they don't tell you that you can't pay money for it. So the conflict in the ECT is probably ultimately a monetary one, because the ECT doesn't stop you from phasing out an energy form as well. The question is just, if you want to do it tomorrow, you know, considerations of energy stability and we don't want to freeze in the winter aside, it's a question, I can stop as a state coal-fired energy tomorrow if I want to. I mean, I may have a blackout in my network and there will be another factual set of issues, but if I pay for it, I can. Now, and under the Energy Charter Treaty, the dispute is almost always about money. So it is, in fact, a question between the state budget and what the state can afford. Now, the crunch comes, what if the climate change obligations and the need to phase out conflict with a dearth of money on the state level, and how that would have to be considered. So that's usually the crunch question in those cases. I also wanted to open another can of worms, climate change litigation, because in a first instance, we look at states taking measures and then companies going to investment arbitration. Sylvia has mentioned the cases of Uniper and RWE. But we had the Shell case in the Netherlands, where Shell was, there was a verdict against Shell, which is being appealed, that they basically need to wind down their business or by half in a very short time frame. There are 4 other such cases pending in Germany. One, full disclosure, we're acting for one of the companies, where NGOs are trying to stop, in our case, yet another energy form, in this case, gas. Now, states have an obligation to procure an independent judiciary. However, that independent judiciary, as in the case of the Netherlands, may come out in a way that a state may be liable for it internationally. So that's going to be maybe an even more hotly contested area if the state courts don't just deny those claims. And that's a risk that states can far less control than measures taken by Parliament. So that's going to be interesting, and I will not go further into this for other reasons.
Thank you, Sabine. Baiju wants to add a brief comment, and then we can move on.
Thank you, Cosmin, and I'll be very quick. I want to pick up on this phrase regulatory chill, which I think we hear all the time. And I want to say 2 things about it. One, I think regulatory chill is not such a bad thing. If an executive or a legislature just sits back and thinks about it, just means think about it, right? For me, it means what are the consequences of what I'm about to do. The second thing I would say is that it doesn't mean, and this goes to Sabine's point, it doesn't mean don't do it or you can't do it. You have the power to do it. It just means there may be consequences, and that consequences are entirely monetary as to if you do it or not. So when you have competing treaties, competing international obligations, this is not the only place where one has competing international obligations. States deal with that in pretty much everything they do on an international basis, which is competing international obligations. So I would say that regulatory chill and thinking about what you want to do and why is not such a bad thing. And then I would go to your point, Cosmin, on legitimate expectations. Now, I won't say where the bar should be because of the cases I'm sitting on, but I would say that with regard to the standard as it has been drawn on legitimate expectations, it's quite high. So in other words, one is not going to get compensation as an investor, and this maybe links into what Luke's going to say. One doesn't get compensation as an investor for legitimate expectations that are not entirely legitimate. One has to have a very clear showing of a drastic change in the promises made to you, whether they are contractual or legislative. So I think I somewhat reject the notion that bilateral investment treaties or multilateral investment treaties are anti-environmentalist. I think that as a philosophy I reject. I think it's more a case of, as Sabine says, a policy choice, a monetary choice, where you're going to spend your money, what are the consequences of that, and if an investor is to be compensated for that, it's a pretty high standard. So I see this as a bit of a storm in a teacup in the sense of NGOs and others would like to see BITs got rid of in any event, and they're hanging their hook on the environmental story, I think, as a way of pushing their own agenda.
Thank you. And now let's move on to regulatory instability in the energy sector. Luke, the floor is yours.
Thank you very much. It's a pleasure to be with you this morning, albeit virtually. I was very much hoping to be there in person, but work took me the opposite direction to California this week. So here I am at 3 a.m. in my kitchen. What I'm going to be talking about just briefly this morning is the tremendous opportunity for investment in Romania's renewable energy sector and the potential implications for investment from the regulatory instability that has marked Romania's energy law for at least the last decade or so. As everybody in the room there certainly knows, the potential for renewable energy development in Romania is quite impressive. Various analysts have placed Romania among the most promising regions in Europe for investment in renewable energy. Just a few statistics. A 2017 report by the International Renewable Energy Agency identifies Romania as having the largest solar and wind potential in Southeastern Europe. Romania is the European Union's second largest producer of natural gas. And according to estimates by Hydrogen Europe, Romania ranks fourth in the EU in terms of the potential for the development of hydrogen, which seems to have a significant potential in the aerospace industry. Overall, it is anticipated that Romania's renewable energy sector will grow sixfold in the future. In line with these projections, according to the government's draft energy strategy for the next decade, Romania plans to invest 22 billion euros in its energy sector. The European Union plans to dedicate another 16 billion euros for renewable energy projects through its Modernization Fund and Recovery and Resilience Plan. So with that potential in that government subsidy, you can anticipate domestic and foreign investment in Romania's renewable energy to grow substantially in the coming years, which raises an important question. Given Romania's history of regulatory instability and its relatively uncertain framework for renewable energy currently, what are the implications for the future? A 2019 survey of senior executives of energy companies operating in Romania says the following. They view the greatest risks being involved in the Romanian energy market associated with the support scheme, balancing the cost of what they view as non-professional authorities, and the many changes and interpretations of the law. Legal, regulatory, and fiscal instability and unpredictability were cited most frequently by respondents as the greatest risks within the renewable energy market, as factors that jeopardize investment, which imply high risk, which are usually undertaken in the long term. The law, just by example, regulating renewable energy producers was passed in Romania in 2008 and approved in 2011 by the European Commission with respect to state aid. That law underwent 11 changes over the next decade. And it's also of note that between 2010 and 2020, Romania has had 10 different governments assuming power and 14 different prime ministers. So this is a regime that is quite active and fluid. Against that backdrop, there are many anticipated changes also coming down the pike with respect to the renewable energy. For example, there will be secondary legislation of the 2012 energy law by the National Authority regulating the energy sector. There will be an implementation of a new renewable energy support scheme, and there is currently underway preparation of an offshore wind law. So even the law with respect to renewable energy is currently in progress. And to provide some further context, 8 of the last 11 investment arbitration claims brought against the state of Romania since 2015 have related to investments in the energy sector. And of those 8, 5 specifically relate to renewable energy production products, and might want to talk about those very briefly. These cases are not generally publicly available, but what is reported in the press and in some international arbitration blogs indicates that the heart of these 5 renewable energy disputes is Romania's green certificate scheme. To greatly oversimplify, the renewable energy investors are complaining breaches of the ECT or Energy Charter Treaty because Romania changed the laws with respect to green certificates dating back to 2011. Essentially, under this scheme, if there was a certain amount of renewable energy provided to the Romania energy grid, investors would receive certificates that would effectively require purchasers to buy a fixed quota of these green certificates, the purchasers being the ultimate industrial or domestic users of the energy source. But starting just 3 years later, in 2014, Romania started to reduce those quotas, prompting a loss of what's estimated to be about 1/3 of the revenues for those investors. And it's this change in the green certificates, which was primarily generated, according to press reports, by concerns of higher prices from the end users, and also some lobbying activity by the source of traditional utilities that led to the change in the law. All of those cases are currently pending. They have not yet been resolved, but they do portend a potential future disputes with respect to future changes to the renewable energy law with respect to future investors in the renewable energy sector, as I talked about at the very beginning. And what investment state precedents teach us, going to what we've been talking about in terms of fair and equitable treatment and legitimate expectations of investors, is that tribunals will take into account a state's current historical, legal, political, and cultural economic situation at the time of the investment. So an investor coming in today with the knowledge of these changing laws, with the knowledge of these existing investment disputes, will likely be deemed to be put on notice of potential changes in the future with respect to renewable energy laws, which raises the question about what type of certainty, what type of legitimate expectations the investor can have. In assessing claims of an investor's expectations of having some stability, tribunals have considered whether such expectations jibe with the host state's general right to regulate. And to go to what Sylvia was discussing earlier, some states now are arguing in the environmental space, in the health and safety space, even with respect to financial regulation, that those core police powers actually have a immunity from the obligation to pay. These are viewed as non-compensable regulatory takings. And so there's an argument that even with respect to some of these laws, there may not be an expropriation obligation, or that any expropriation could be excused given the core regulatory issues at stake. Similarly, states will say that they have a legitimate right to change laws with respect to renewable energy, at least so long as those laws comply with due process and are non-arbitrary. So that is the background in which an investor will be coming into the Romanian market. And to quote the tribunal in Mikula versus Romania, the fair and equitable treatment standard found in most investment treaties does not guarantee regulatory stability per se. Tribunal wrote the state has a right to regulate, and investors must expect that the legislation will change absent a stabilization clause or other specific assurance giving rise to a legitimate expectation of stability. Similarly, Duke versus Ecuador's tribunal held that the assessment of the reasonableness or legitimacy of an investor's expectations must take into account all circumstances, including not only the facts surrounding the investment, but also the political, socioeconomic, cultural, and historical conditions prevailing in the state. So in evaluating whether future changes are substantively proper and procedurally proper, the Mikula Tribunal said that you look at, from the state's perspective, whether the state was pursuing a rational policy, a non-arbitrary policy, a non-discriminatory policy, and whether the state acted in accordance with the regular laws and procedures in place in that country. Because of the likelihood that absent specific assurances, investors may not be protected against future changes, you can imagine that one of the issues being negotiated currently in Romania will be whether or not the state will provide some type of specific assurance or written stabilization clause to induce an investment that might otherwise not be made. There are various forms of stabilization clauses, and they're hard to pin down because oftentimes they're different, but you can have clauses that effectively freeze the law in existence at the time of the investment. These freezing laws prevent the state from applying at least any unilateral changes in the law as it exists today. And the freezing therefore allows the investor to make certain assumptions about future rate of return, tax regime, royalty regime, that allows them to decide whether the investment will ultimately be worthwhile. There's also economic equilibrium terms. We've already been talking about how states can take action as long as there's monetary compensation for the deleterious consequences of the change. And these economic equilibrium clauses simply call for the economics of the project to be maintained. And finally, there can be renegotiation clauses, which are a little bit more open-ended, but require some renegotiation to restore what was the anticipated status quo when the agreement was signed. So the case law with respect to these stabilization clauses is not robust, but generally stabilization clauses have been upheld both under domestic and international law. One thing that I have seen in practice is that states oftentimes say that they cannot be bound by a stabilization clause because it infringes on their sovereign authority to change the law as they see fit. Most tribunals have rejected that argument, saying that the initial decision to enter into a stabilization clause is itself an exercise of sovereignty that must be respected. And so we will be very interesting to see how this develops in the future with the growth of the renewable energy sector in Romania. And with that, I'll stop, Cosmin. Thank you very much.
Thank you, Luke. One brief follow-up question for you. Obviously, there has been regulatory instability. There will be changes, and the context is perfectly appropriate for some other more or less significant hiccups. There is no such thing as like a hornbook for states to use and make sure that they are not going to get in conflict with investor rights. And hence my question, because who knows, perhaps the Romanian state or some other states are watching us today or later. What would be your advice, one or two practical advice, punctual, for a state contemplating changes in legislation in a cautious way that would not trigger a wave of cases against the state because of that legislative change? Thank you.
Well, to me, I think change is going to be inevitable. And if I were advising a state, I think the important decision is really what you do at the outset. What is your framework in trying to have incremental changes that will not, that will inevitably come up, but that will not necessarily expose the state to potential claims in the future. I think the benefit to states of providing a relatively stable environment is, at least in theory, it should allow them to attract better quality investment at a potentially lower cost, because it's the uncertainty for these major long-term projects that require such substantial investment at the beginning that you have to look at the long term to see what your returns will be in 20, 30 years. That's the primary concern of the major investors. And so if there can be some arrangement ex ante that you have the ability to incrementally change laws in a way that will not be hugely disruptive of the project, I think that is probably the most important thing, and that would really have to be done at the outset.
Very interesting, thank you. And now a question from the floor, Karina. You can use that mic.
Thank you. I just wanted to pick up on what Luke was saying, stabilization clauses, and your question, Cosmin. And to me, it seems that in these energy projects and investment disputes, the ones that are going to suffer quite a lot are the small investors. And in particular, if we look at the Energy Charter Treaty cases, we see that the renewable cases are mainly having small and medium-sized investors. The big ones, if we take any Shell, it was an example, they'll probably have the power, the bargaining power, to either negotiate a contract directly with the state or be able to knock at the door and make sure that they'll be fully protected. So what's your view, in particular, looking at the climate change transition about these small and medium investors?
Thank you, Karina. Now, the next topic is an innocent one, not at all actual, sort of like a theoretical storytelling. Baiju, the floor is yours for the following 3 hours are enough? Okay, then let's make it 10 minutes.
Thank you, Cosmin. Good morning to everyone. Let me start by thanking the organizers for inviting me. It's always a pleasure to be back in Romania. This is my 5th visit. I have never made it out of Bucharest, so to which I apologize. I promise I will not make it 6 visits without not seeing your beautiful country. Let me also say that it's an absolute pleasure to speak with all these esteemed panelists who I've known for many years and who I hold in great respect. Cosmin started by saying that I'm a bit of a storyteller, so I feel now obligated to tell you a bit of a story. So I'll tell you about my grandmother in 1992. So the dear lady is now 93 years old, and she's very into astrology and tarot and palm reading. Indians, I don't know if Romanians share that, but we're very into superstition and sort of what's in the stars for you. So she decided, she had 9 grandchildren, and she decided that she's going to invite this famous face reader from India. So she flew this person all the way to London and said, read my grandchildren's faces, please. And I was first. I was the oldest grandchild. I was 17 years old. And I remember sitting there in the dining room with this man, and he started almost like a plastic surgeon, right, looking closely at my face, going right up to it. I felt very conscious. And then he told me 4 things. He told me, first of all, I was going to be a millionaire. And I was ecstatic, right? At 17, I thought, this is the best thing I've ever heard. Then he told me I'm going to die age 72. I was less happy about that. I thought, well, as long as I'm not a millionaire at 71, I'm okay with dying at 72. Then he told me I'm going to be married twice, and my second marriage will be happier than my first marriage. And I'm now married for the 17 years with my first wife, and I remind her that don't be nice to me because my next wife is going to be even nicer than you. And then finally he told me, and this is where I lost faith in his prediction, he told me I'm going to be a millionaire in the shoe industry. And here I am as a lawyer with nothing to do with shoes. But this story is a way of saying, I'm going to try and predict, and I think Sylvia and Luke have both touched on this, what I see as potentially the next 10 years in the energy industry in Europe, and perhaps even, if I could, for Romania. And I'm going to do that through the lens of sanctions. So I think we heard yesterday about how the EU has wanted to, and has always wanted to, move Europe away from fossil fuels and towards renewable energy, right? It's been this great green wave, and they've made missteps, or you know, at least some tribunals have found them to have made missteps. But there is still a great desire to move away from fossil fuels. And now you have a push on sanctions against a great fossil fuel provider in Russia. Now, I should say I spent the last 3 years in Russia defending the Russian Federation in various cases, so I'm quite familiar with their position on the issue, but of course I'm going to take as neutral a position as I can. Now, the first thing I'd say on sanctions is that they have been around for decades, right? So this is not new. It's a hot topic now. Everyone wants to talk about sanctions. But the fact is, sanctions have been around on Russia since 2014, Venezuela, Iran, various African nations, many of them as energy and oil producers. So, you know, as I said, this is something that's been there for a while. What's different, I think, this time is simply the amount of sanctions there are now on Russia. It is now de rigueur, and it is the way that the EU, the US, the UK, and others are seen as pushing back on Russia with sanctions, particularly you'll see in the energy industry, right? So they're saying, well, look, we want to push back on Russia with sanctions economically. We're going to isolate you, and we're extending, and every few weeks you see extensions of the amount of sanctions they're putting. Now, question one is, does it work? Probably not, right? Because they, for 2 reasons. One is because the EU is never really going to wean itself off Russian oil and gas. The second is that if we as Europeans come off Russian oil and gas, someone else will buy it, right? So it's kind of just simply a movement of Russian sellers from this part of the world to that part of the world. But what it definitely is going to do, regardless of whether it works from an isolation point of view, it is going to change the face of energy in Europe. And then the question is, well, what does that mean for us as lawyers in the energy industry in the European Union? So here are my predictions. They're not particularly, I would say they're not particularly predictive in the sense that I think they're maybe quite obvious, but certainly I hope that they will be of interest to us for discussion. The first thing I think is you're going to see a lot more reliance on home energy, right? So each country is going to push, even if it's fossil fuel. So Romania is going to push into its gas into the Black Sea, for example. You're going to see more and more emphasis on domestic, state-owned energy producers producing more and more of the fossil fuels for which we can. The second is going to be diversification. So in place of Russia, you're going to see maybe Qatar, right? Or places in Latin America or in Africa. So really there's that diversification of clients. Europe is a net buyer of energy, and instead of buying it from Russia, we're going to buy it from other nations and other states around the world. the third one is renewable energy, and this is what Luke and Sylvia talked about. There's going to be this re-push. I think this, what I would call the second cycle. You had the first cycle back in the early 2000s with the 2020 that got into all these investor state cases. I think we're going to see now a new one into the future. And then the fourth one, I think that's interesting, is simply the continuation of Russian relationships. They won't be as strong as before, but they are not going to go away. It is not a case, and I heard this morning that as much as the states are talking about getting rid of Russian reliance by end of 2022, it's simply not going to happen. So Russia is here whether we like it or not. Now, what does that mean for all of us as energy lawyers and dispute lawyers? Well, I think the most exciting part are the new contracts. So those of you who do corporate law or have corporate partners, your partners are going to be busy because they're going to be busy diversifying the energy, looking at more domestic drilling. It's going to be a busy time for energy lawyers. Renewables is going to come back into play. New supply chains. For example, to make solar panels, you need cobalt. To get cobalt, you have to go to DRC. For DRC, it's primarily invested by China. You're going to see these whole new geopolitical chains as a result of this new push in different energy directions. And the other one is, how do we deal with these existing Russian contracts? And on sanctions, I just wanted to list for edification and in some sense, hopefully for debate, how we're going to deal with it. So the first thing is, what do we do with the existing contracts? And here are some of the issues that could arise. You'd have the difficulty to perform some of the contracts because of sanctions. So some of your clients will actually not be able to perform their Russian contracts because of sanctions issues. You'll have potential for some of your clients breaching sanctions inadvertently, either through financing, and remember that, for example, US sanctions are very, very difficult to get out of, because to be a US person, it's not just a US citizen or a US company, literally anyone doing business directly or indirectly with the United States. There could be a practical impossibility, what in English law we would call frustration or impossibility to perform your contracts, which may involve force majeure. Your clients may just simply want to pull out of the contract. They say, I don't want to be doing business with Russia. I don't want pickets outside my offices. I just want to be seen to be clean of doing anything with Russia. And what does that mean? You'll have Russian clients, and Russia itself maybe putting a positive aggression, if you like, legal cases against your clients if they try not to pay, for example, they don't want to pay in rubles. And then I think you're going to get the general turmoil disputes that arise out of this attempt to detach ourselves from Russian oil and gas. And then what will that then lead us to is arbitrations, right? Because most of these energy contracts have arbitration clauses, but you've got the background of sanctions in relation to these arbitrations. And just again, to put in just a list of things that I see, potentially these sanctioned entities can't pay for to participate in these international arbitrations because their assets have been frozen. You may have institutions or individual arbitrators who say, I can't be paid by that entity that's sanctioned, right? They have to pay half the costs. I don't want that in my bank account because it's going to be really bad for me. Or the ICC or the LCA or Romanian institution that says, we can't have that money sitting on our account because even if technically we could, our bank is telling us, what, you're getting money from Russia? That's, you know, are you sure? And it creates a lot of issues just simply from a practical perspective. Legal representation. The London market grew fat on Russian money, right? We do. I have to say that as a Russian lawyer. Sorry, as an English lawyer who was in Russia. But now we're holier than thou and saying, well, we're pulling away. We don't represent Russian clients anymore. But the truth is that, you know, we did it for a long time, and as soon as this is over, I'm sure they'll go back. But the fact is that Russian clients today are struggling to get anyone to represent them, and that could be an issue. And then the final thing I would say is third-party funding for Russian clients who can't bring their cases. And what you end up with is potentially a pushback by Russia. You have new legislation, you have potential cases where if an arbitration is brought in a country that has brought sanctions against Russia, you can potentially be brought into the Russian courts, right? That's a way that Russia is pushing back against sanctions, is that your entire case will be moved to the Russian courts and dealt with in Russia instead of in sanctions. And my final point, Cosmin, and I'm sorry if I've run a little bit long, but I did look at Romania and the situation of Romania, and you guys are pretty good compared to the rest of Europe. So your share of imports of Russian gas are only 15.5%, well done. 30% for crude oil, not great. 12% for coal. But the truth is, that is not bad, right? Compared to, for example, sorry, Sabine, Germany and others, that's a pretty good position to be in versus the rest of Europe. So in a sense, I think, although you will continue to have the issues vis-a-vis Russia, dependence on Russian oil, the arbitrations and sanctions, I think in some sense what Luke said is that you could be the leading European nation for moving forward. I think that is right because you have a position that is not so tethered to Russia. And I think that's a very good position to be in and one of great opportunity.
Thank you, Baiju. I would like to take advantage of a little bit of your fortune teller skills and provoke you with at least two punctual issues. The sanctions as they look today, they are continuously being enacted by means of regulations. To a certain extent, or punctually, they have a sort of theoretical, absurd abstractness. I am able to provide an example. It's not from energy field, but I think it is the most suggestive can ever exist. I read in a regulation that as of whatever date, in April or something, all the states are supposed to suspend / prevent any transfer of cryptocurrency accounts exceeding 10,000 euros. If the metaverse itself, whatever that means, moves to Romania, the Romanian state is unable to do anything because there are no regulations whatsoever allowing the state to know that a transfer of cryptocurrency takes place in Romania. I have examples, but I don't want to publicly talk about them in the energy field. My question is this the result of the rapidity and the context, or is another kind of game being played? Because the sanctions as they are today, they are not, or they cannot be as efficient as apparently they should be on one hand. And on the second part of the question, what do you think it would happen if one day, for political reasons, perhaps in Poland, perhaps in Hungary, perhaps in another state, or perhaps in arbitration proceedings, an award is going to be issued and is going to state that X sanction is not efficient and cannot trigger any effect, I don't know, upon 1 billion contract. Is the EU, who turned out to be a big friend of investment arbitration in Achmea and Comstroy, perhaps expected to take position even against arbitration, because arbitration may turn out to be, in a certain context, not friends with the sanctions?
Yeah, I think these are fabulous questions. They go. I'm not a sanctions lawyer, I should say. I'm an arbitration lawyer, but I would say this, that I think sanctions are increasingly used as a geopolitical tool. So you had, for example, let me give you an example. The US sanctioning Putin and Russia sanctioning Biden, meaningless, absolutely meaningless. They're just ways of showing that look at what we're doing, look at what we're doing. The one that had some teeth was the movement of the Russian banks out of SWIFT. That had some issue, but again, where the Americans and the Europeans come out, the Chinese and the Indians will come in. So really what we're not, my own view of sanctions, and as I said, this is from almost a layman's perspective, is that they are a geopolitical tool, but they're simply realigning the way things happen. They are not isolating Russia, I think, in the way sanctions want to be. But what they do is make life for our clients hard. They make life for us hard, and they make life for our clients hard. And that is an opportunity for us as lawyers, because our clients won't be able to do certain things that they want to do. But ultimately, do they work from a basic geopolitical, philosophical perspective, I don't think so. To go to your second point, I think the European Union will use anything, right? Sanctions or third-party funding or state aid or whatever it can get its hands on to attack ISDS. So the answer is absolutely yes, they will do that.
Baiju. Unfortunately, we are running out of time and we cannot further develop this issue, so we have to move on to financing instruments as investments in the energy sector. Sabine, the floor is yours.
Thank you. And I think I will start with a reference to Baiju's and sanctions and advance on costs. Now, I maybe naively believe that arbitration is access to justice, and that it's in the interest of all parties involved, even a party finding itself opposed a sanctioned party, to have the dispute decided in the forum that they elected, because as Baiju explained, then suddenly you find yourself in front of a domestic court of the state against which sanctions have been issued. Now, for that, you need counsel for both sides, and you can say that in Russia, the Russian bar and Russian lawyers have become so experienced that they don't need the Western lawyers, granted, but you also need arbitrators. And you don't want to put the burden on the arbitrator to check whether or not he or she can accept payment, because if he or she is responsible for doing a sanctions or money laundering review as to whether or not they can take the advance, you could say that they're already, say, for example, money laundering or corruption is an issue in the arbitration, that they are taking sides and making a decision by making the decision whether or not to accept the mandate to be an arbitrator. So I find that somewhat problematic, and my preferred solution would be to make it a problem of the institutions. So for them not to hold the advance in trust on behalf of the parties, but to accept it as fee and from there pay the arbitrators, a bit similar to what ICSID does. In ICSID, you send your bill to ICSID, which makes it a lot easier if you're an arbitrator working for a law firm to be paid by the World Bank. With that, since money is my topic in this decision, I switched to the real one of financing. Sorry, Baiju, why don't you react?
We are fine. That was a technical issue, but now it's solved. Go on.
Okay, sorry. Energy transition is not just raising the money question on the dispute stage, but even before on, how do you finance energy transition? And if you look especially at renewable projects, and as Sylvia explained, it's not and also Krina made the remark, it's not the huge multinational energy companies that are driving climate change. Well, they're driving climate change, but the combating of climate change through investing in renewable energies, it's small and medium-sized enterprises, and they use project financing, and often to 80-90% of the money's involved. So you could say the real money is coming from the banks, it's coming from investment funds, and they're the ones that only get interest for the risk, for the investment risk they assume. But if it goes wrong because regulation is passed or feed-in tariffs are changed, the support schemes are being changed, they may also be suffering. In the waterfall, they are first before the equity investors, which is fair given that they've given 80-90% of the capital. But also, once they are affected, they have potentially claims under the Energy Charter Treaty or other investment treaties, which is kind of an underused area of investment claims. There are currently 2 pending against Spain. Full disclosure, we have one of them. And Spain has been challenging the arbitral tribunals under rather flimsy exclusive in all of the energy cases, not just in the banking cases, but also in the sponsoring cases. And it will be an interesting situation to see how other financial investors will react to the next stage of energy transition, having had the experience of, for example, the Spanish renewable cases, where Spain implemented a rather favorable support system, attracting investments in Spain in the renewable sector. And we will see probably the same movement now again, accelerated by the geopolitical need to create energy independence. So the combating of climate change and energy security and energy autarky will go hand in hand. But there will probably come a point, maybe 5 years, 10 years from now, when we'll have another panel in Bucharest. Hopefully I will be there in person, where we will discuss the next wave of investment arbitrations against states that made promises, attracted investment, made sure that the lights don't go out in Europe in winter on the basis of renewable energy, and then find that a new government coming in that is no longer under the impression that it was a vital national need, an international need, to accelerate the transition to renewable energy, and then rolled it back because of budgetary concerns or of other reasons, or perhaps maybe because fusion energy suddenly worked and is commercially available and will then phase out solar and wind energy because also they have environmental consequences. Now, I'm not as good as a tea leaf reader as Baiju's face reader from India, but I think it's fair to say that the problem is going to be with us also in 10 years, maybe under different treaties. Now, if the EU pushes forward with their idea to reduce investor-state arbitration and their attacks on the Energy Charter Treaty, then how are these banks with an 80-90% capital input into renewable energy projects are going to secure their business? Because we're talking real money. We're talking about billions of dollars. One way is structuring to see that the investment also of the financer covered by an investment treaty that's long-term outside the EU. I'm not sure whether they will be, as Krina suggested, be in a position to negotiate a host government agreements with the states in which they invest, because renewable energy, even if you have the financing from big financial institutions, is driven by small and medium-sized companies. You have investment insurance, which is also something that the project owners need to do in the first place, but something that financial institutions can push for. But it will be a busy time for the finance and corporate partners to deal with that. And I think I echo the feelings of all of the people on the panel. Please involve not just the tax structuring people, but please involve the arbitration and investment protection people, because if you get it wrong at the outset of a project, and then you don't look at it for the next 10 years and the proverbial then hits the fan, it may be a not so nice awakening. And since we're short on time, I will end here and only say that I have managed to see more of Romania than Bucharest. I've been to Oradea, for example.
Thank you, Sabine. If there are any comments from the other speakers, please let me know. Until then, I would have my traditional one question for you also, Sabine. Let's ignore for a second the already existing investments in the energy field and focus for a while on the immediate ones. In the second half of 2022, we all agree and we all hear that there are plenty of opportunities and lots of projects are going to be to occur. My question is, in this unprecedentedly unclear and full on uncertainty context, what is going to be the appetite of the banks and generally the financing bodies to jump in and invest millions or billions in new projects? I discuss about second half of 2022, not whatever would happen in 2 years from now on.
It depends on the country, because as of now, the states are in the process of introducing new subsidies, new support schemes for renewable energy. And I know, for example, that the German system is, which they gave us a framework in at round about Easter, is scheduled to enter into force January next year. So I don't think we will see much movement in the second half of 2022 yet, even though the market is going to be ready. We will probably see much more movement 2023. The biggest obstacle right now is not banks, it's not financing. Yes, interest rates will be higher than what we saw back in the day. The biggest problem at the moment is getting solar panels, getting the other electric devices you need for PV, for example. You have a huge run on these parts, basically, that are not widely available. You have it exacerbated by the situation in China with the lockdown of the Shanghai harbor. Plus, then we have other questions about where these panels are being produced, and the cobalt was mentioned, and other constituent parts which come from areas of the world where human rights standards may be lower than we would like them to be. So that is going to be the biggest crunch, and a supply crunch will drive up prices. And if you combine that with higher interest rates, renewable energy is going to be much more expensive than it was, say, 2 years ago. And that will be another challenge for the states. How high do the incentives have to be to make a meaningful influx of new projects into a country? And how does that work in competition with other countries that are trying to do exactly the same thing at exactly the same time? Our commercial arbitration people will be happy, because contracts and changing prices and supply crunches mean commercial arbitrations as well.
Thank you. Very, very interesting. Yes, indeed, we can only wait and see what is going to happen, and which one of all of us is going to be the champion of prediction and the fortune telling. I did anticipate that you are going to witness a perfect panel. Perhaps you didn't believe me, but now I'm sure that you are going to agree that you did witness to a perfect panel. My only dilemma was whether we are going to be able to stay within the allocated time. I was hoping to go beyond a little bit to see if the sanctions that are going to be imposed upon us are of any efficiency, but I was not even able to do this because we did stay perfectly within the allocated time. I can only thank once again to all our panelists. It was really, really, really interesting and provocative and very actual and timely for the topics debated discussion. Please join me in a round of applause for our speakers. And stay tuned, because in 1 minute we are going to go on with the other panel, which is dedicated to Energy Charter Treaty. So the temperature of the debate remains equally hot. Thank you.
Hello, everyone. Thank you for sticking with us. Thank you to the organizers for making this excellent event possible. We are here. You may notice that our the members of our panel are still to arrive. So we are a little bit short, but hope to complete soon. We are going to speak today mainly. We're going to focus on the Energy Charter Treaty. Now, you will have certainly noticed there, in terms of as regards the Energy Charter Treaty, these are times of change. It's going to be reformed, modernized. It's under heavy artillery shells, to use a term pretty used these days, from various directions, particularly in respect of intra-EU investment arbitration. But it's here for a while, and probably for a while to stay. This is why, and I take this opportunity to introduce my co-panelists, Professor Rafael Gil Nievas. Rafael is teaching arbitration at ICADE. He has a long experience in energy and litigation sector. And among his former experiences, I will list only a few, namely Counselor of Justice in the EU, General Counsel for the Americas at Iberdrola, also General Counsel of CEPSA, do I pronounce it correctly? Yep. And of course, an independent attorney at law and arbitrator. Rafael is going to tell us more than a few words, because, well, we have some gaps to fill, about the definitions of the fair and equitable treatment standard and economic activity in the energy sector, as well as the goals of the European Union regarding the intra-EU application of the Energy Charter Treaty. And then we are going to move over to Pablo. Pablo is with Ellen Overy in Spain. Is this Madrid? Okay. Yes. In international arbitration. And Pablo is going to take over where Rafael has left and tell us about the composition of disputes under the ECT, in particular renewable energy disputes, as well as the application of the FET standard in practice by ECT tribunals in renewable energy cases, and proposed reform of the Energy Charter Treaty. We plan to take questions, well, given that we are very flexible, whenever the question arises, just signal it, and then we'll take it. Rafael, the floor is yours.
Thank you, Sebastian. Thank you to the organizers for inviting me. It's a pleasure to be back here in Bucharest again. I was telling yesterday people that the last time I came was 3 years ago, and the improvement that I have noticed in Bucharest is pretty remarkable. Maybe people living here in Bucharest, as you see it day after day, you don't appreciate it, but for someone who has not come in 3 years, we have noticed it. So thank you very much. Well, first of all, a small disclaimer, because now the last 3 years I have been representing the government, the Spanish government, investment arbitration cases. And as you perfectly know, those who are familiar with investment arbitration, whatever is said by any person working for the government can be used against the government at some point. So what I'm going to talk about is my academic point of view and should not be attributed to the Kingdom of Spain. And furthermore, because I'm leaving the government I have already left most of my cases, and formally I will leave in 20 days. No? So let's focus on the topic: multilateral perspectives, energy disputes in the international context, and we focus on the Energy Charter Treaty because there are some other multilateral treaties who can be the basis for investment arbitration. And I'm thinking, for instance, in the NAFTA or in the Central America, the CAFTA, Central America, Dominican Republic, and the US. And all of them have also investment protection provisions, no? So, but let's focus on the Energy Charter Treaty that it has been the base of, I don't know how many, but I think that more than 100 investment arbitration cases. And now there is a process of what is called modernization or reform of the Energy Charter Treaty. And we have to take into account which ones are the actual possibilities, because and if it's absolutely necessary or not. Because Italy, for instance, withdrew from the ECT, and people may think that this had affected the investment in renewable or in energy sector in Italy. It has not. They withdrew in 2015. Nevertheless, if you see the stats of the investments in Italy from 2015 to 2020, they increased the investment in the sector. Nevertheless, we have to analyze which ones are the possibilities, and everything depends on the country. The possibilities regarding the ECT is that it remains as it stands. It may happen. The possibility is that another possibility is that a few contracting parties are not happy because the modernization does not move ahead, and they withdraw. And the third possibility is that there is a new Energy Charter Treaty. And do we need the Energy Charter Treaty? And do we need investment protection there? And this is a good question, and my personal opinion is that yes, we need it. So I know that investment arbitration, we are, it's our way of living, investment arbitration, so we are great defenders of investment arbitration. But in some other places, it's criticized. And we have to analyze with some neutral point of view if we need it or not. Because, for instance, Brazil has not signed any investment arbitration treaty, and they receive a lot of energy investments. So we have to be aware of this. So investment arbitration, but we need it or not. And sometimes the best lessons in life come from history. And if we go back to history, we have to think how investments in few cases or in particular situations were defended. And were defended through diplomacy, or even worse, through war. And this sounds like, okay, this is crazy, but it's not, because in 1956, there was a Suez, the Canal War, in order to protect the French and British investments in Egypt. 1956. What happened then? 1958, New York Convention. 1959, the first bid, Germany, Pakistan. 1965, Exit Convention. So we had the perfect, I don't want to call it a storm because it was something positive. And what's the message of this? We need investment arbitration. We need it because otherwise something as the Suez Canal can happen again, and we don't want this to happen. In extreme cases, So, having as a starting point that we need investment arbitration is, do the provisions related to investment arbitration in the ECT demand an improvement, yes or not? Or they are capable of having an improvement, yes or no? And the mere fact that we are discussing about the modernization means two things. First, we are focused on new sources of energy, and we are thinking about the protection that we should give to different sources, if it should be the same or different. I mean, which ones are going to be the environmental and the green goals for the future. And second, there is a big discussion also regarding the modernization of the investment protection related provisions of the Energy Charter Treaty. I am a negotiator of the modernization, but I cannot, of course, disclose anything, so I will talk in general about what we are going to talk. So first, the standard of protection. And we go here to the classic discussion. So we have talked about expropriation. Expropriation is clear. We have talked about other, about umbrella clause. But, you know, the main protection use, the main standard use, it's always the fair and equitable treatment. So the point is, do we need something that develops, limits, frames, or to some extent give more precision regarding the fair and equitable treatment? Is it possible a closed list of infringements? So regarding this question, my opinion is that at the end of the day, if we have arbitration, it's because we rely on arbitrators, and some degree of discretion is unavoidable. It's completely unavoidable. But you can frame the concept, yes, and we have to another starting point. Which one is the obligation of the arbitrators? Which one is the obligation of the arbitrators? The obligation of the arbitrators is to apply the law. They don't have, they should not create requirements when they are not. They should not create limitations when they are not. They are obliged to apply the law. And which one is the international law? Which one is the international law? We're talking about the ECT, but the ECT is a treaty. When you have an international controversy, from my point of view, the first step that you have to take is to go to the Article 38 of the Statute of the International Court of Justice, the sources of international law. You go to the sources of international law, and one of the sources is international conventions. Okay, let's see which international conventions are applicable. Second source is, they are not hierarchically numbered, is international custom. And third is general principles of law. What do I want to say here? That it's also quite important, first, that the arbitrators don't create the law. Second, that they don't consider the precedent as law. Because the Article 38 of the Statute of the International Court of Justice says that judicial precedents are a subsidiary mean in order, or ancillary mean, in order to determine which one is the applicable law. They are not law. But we all have seen this, what I see, it's regrettable practice sometimes of copy and paste in arbitration awards. I think that's not a good practice, and that's generates criticism about international arbitration. No. Arbitrators have to some extent, isolate, consider the circumstances of the case, and judge the case, that particular case. And because the circumstances, even the allegations of the parties in each case, change. Keeping with linking this with the standard of fair and equitable treatment. If you don't frame it a little bit, you have to go to the circumstances of the case. So if you don't frame it a little bit, you go to the circumstances of the case. And this is perfectly fine. But if you have to go to the circumstances of the case, to the objective, subjective expectations of the claimants, to the conduct of the state, and how this has been alleged in previous cases, you cannot, arbitrators, base your decision on previous decisions because the circumstances vary. How can you limit the concept? And this is something that it's, I think there is a press release of the Energy Charter Treaty Secretariat regarding this, so that they are thinking on framing the concept of fair and equitable treatment in the ECT reform. And there are many ways. So you can link fair and equitable treatment with minimum treatment in accordance with international law. We can do reference to legitimate expectations taking into account national laws. You can mention the regulatory powers of the state, or you can use something that it's used in the ICSID Convention. You can use what I call qualifiers. What do I mean by qualifiers? The ICSID Convention talks, for instance, in order to challenge an arbitrator, that he has, or he or she, manifestly lack the conditions for being an arbitrator: impartiality, independence, manifest. So you can use this in order to qualify the definition of the fair and equitable treatment. Or you can even talk about the burden of proof or the standard of evidence, say that it has to be manifestly evidenced and demonstrated that this has happened. But at the end of the day, even if you use qualifiers, you need some discretion, some arbitrator's discretion. Otherwise, it's not possible to make the system work. Another question related with the modernization of the Energy Charter Treaty. We have talked about if it's going to be framed or not, the definition of fair and equitable treatment. Even if it's framed, at the end of the day, you need some degree of discretion in the arbitrators. It's completely unavoidable. Second point, what should be protected? Do we define a little bit better what an investment is, or what an investment in the energy sector is, in order to delimit a little bit which one is the scope? Or do we protect every single energy-related investment, regardless the source of energy, if it's fossil energy or non-fossil energy? This is something that it might be discussed. Ideas there. Well, first, an investment should be an investment. So an investment should be an investment. We can go to a Salinis test, or we can go to a different test, but an investment should be an investment. Do we define in a limited way, in a closed list, the kind of assets or investments? I think it's the same thing. It's almost, you can create an orientative list, but at the end of the day, you need some degree of discretion on the arbitral tribunals, based on you need to rely on their common sense, and that they will not consider an investment what nobody would consider an investment. Second, what is the investment in the energy sector? We have talked, for instance, about financial services before, and some operations are a combined and a single commercial operation. But maybe for nuclear plants, it's also a single commercial operation, the contract with the water provider, because water is essential in nuclear plants, and correct me if I'm wrong. What is the limit? What is energy? And do the providers to the facilities qualify as investors or not? Do we accept reflex losses and reflex protection, protecting indirect, we wouldn't call them investors, but indirect providers or services providers, or even money and financial services providers, or not? This is something that should be discussed. And third issue, that it should be defined, and it has been mentioned in press releases, is the relationship between the EU law and the EU treaties and the ECT. And this could be considered in a twofold way. So regarding the famous intra-EU objection, where investors say, okay, I rely on the law of treaties, and I rely that this was enforced, this treatment, the ECT, was enforced. On the other hand, the EU and respondent states are saying, okay, no, we responded, you don't have more rights than those that are granted by the states, and the states are obliged to comply with the decisions of the EU Court of Justice. So at the end of the day, it's a fascinating debate. They can say that this is already decided because courts unanimously have rejected the intra-EU objection. But I listened the other day to a sentence that was magnificent, because it said, and yet it moves. This was what Galileo said when all the scientists in the world were saying, no, 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 the Earth is flat. And he said, okay, I have to accept that now, but and yet it moves. I'm sure that sooner or later the debate is going to continue, and sooner or later is going to be an award saying accepting the intra-EU objection. And the second point of the EU, and the debate will last for, I think, that a decade for sure. The point is, if in the modernization it said something or not. So if it said something, even in a declaratory statement, saying the EU has always understood that this was not applicable intra-EU, because if you include a new clause saying that in the new treaty that this is not applicable, contrario sensu, before it was. So at the end of the day, it's a marvelous legal debate that we are not going to decide now, but I want you to remain this, and yet it moves. So something is going to happen yet, no? And I had more things to talk about, but what I don't have is time. So, okay, so the second point of the relationship EU-ECT is, from one part, the intra-EU objection, second part, the applicable law. If you have an international dispute, if you have been an international litigator, you first decide which one is the competent court, and then, if it's an international dispute, you go to the conflict of laws, to the conflict of law rules. And conflict of law rules, the starting point has been said, that is the Article 26(6) of the ECT. Perfectly fine. But what happens if we go before to the Article 38 of the Statute of the International Court of Justice, to the sources of international law for resolving international controversies? Maybe in that case, the ECT is applicable only at the same level at the EU treaties. And in the EU treaties, you have this debate regarding the state aid laws. So, and the ECT has its own rule on conflict, it's Article 16, and the EU treaties have their own rule of conflict, that is the Declaration 17 of the Lisbon Treaty, declaring the primacy of EU law. And just to sum up, so there are amazing challenges and amazing legal discussions in front of us. I hope that the arbitral tribunals do not follow what a famous arbitrator once called the parrot effect. So parroting, copying and pasting previous decisions, because there are new arguments, there are new elements, positions may change, and we have an amazing and interestingly, for those who love law, an interesting debate ahead of us. So, thank you.
Muchas gracias. I will try to make a combination between what were the outgoing, one of the outgoing conclusions of the previous panel, trying to predict in the future, and your pur si muove. We are now at around 60 copy-paste, thank God, from the perspective of an investment arbitrator, decision whereby the intra-EU objection is rejected. What's your take? So pur si muove, when? Is it with number 100, will we get one that's going to be admitted? I'm joking a little bit now.
No, it's, the point is that I don't know what is going to happen. I don't know what is going to happen. I know that new arguments are coming. I don't take a position, first of all, but it's quite interesting that some mistakes are copied and pasted. For instance, many awards say without a disconnection clause, it's not possible to disconnect. The practice of the European Union for half a century has been the contrary. And I'm going to put you an example. One of the most important conventions worldwide is the Apostille Convention, the Hague Convention on Apostille. It doesn't have a disconnection clause. Nevertheless, there is an EU regulation saying no matter, EU regulation, not an international convention. So if you go to apply the law of treaties, it wouldn't have any sense. It wouldn't make any sense. There is an international regulation saying an EU regulation saying no matter what the Apostille Convention says, within the EU, we apply this, and we don't need apostille in order to give validity to a public document in a different country. If we follow the doctrine of disconnection clause is necessary, in fact, we would be in real troubles here in the European Union. We wouldn't have the European arrest warrant because the extradition convention of the Council of Europe would apply. We wouldn't have the Brussels I regulation. Brussels I regulation supersedes an international convention, that is Brussels Convention. So at the end of the day, this mistake that it's absolutely necessary, disconnection clause, it's a big mistake that has been copy and paste. You can use different arguments. And I don't say, because there are some valid arguments in favor and against, but the demand as an absolute requirement of a disconnection clause, it's a mistake, goes against the international custom, that is source of international law, goes against a practice followed and accepted by law by member states for more than 50 years and accepted by all the international community, because none of the 150 state parties of the Apostille Convention has ever complied about, okay, you cannot use this, and because international conventions have to be applied in a uniform way. No. So at the end of the day, let's see what happens, but let's see what happens. But some arguments cannot be used from my point of view.
It will stay in this discretion of the arbitrators you were mentioning, right?
Well, discretion under the application, under the obligation to apply international law. And what's the point? For instance, we were talking about international custom. International custom must be alleged and demonstrate. There is not you're an arbitrator regarding international custom. Has been it done? Maybe yes, maybe not. So let's see what happens in the near future.
Thank you very much, Rafael. Now, Romania is pretty much of a consumer, put it this way, of the Energy Charter Treaty. We have out of, when mine count, 13 pending cases against investment cases against Romania. 8 are based on the Energy Charter Treaty, and out of those, again, my count, 4 are renewable energy. In this context, we are going to move to Pablo. And Pablo, the floor is yours.
Thank you, Sebastian. Now, I'd like to start by saying thank you for inviting me and for the wider organization for inviting me to form part of this panel. It's my first time in Bucharest and hopefully not my last. It's an honor for me to participate in this panel together with such a high caliber panelist as Rafael. And in the context of this panel, energy disputes under the ECT, I would just highlight that I've been involved in a number of considerably ECT cases against Spain since 2014. And I might add that in those cases, I've had the pleasure of acting opposite Rafael in a number of those. Now, the general theme of my presentation is going to be the composition of disputes to date under the ECT. A number of the issues that I will address have been somewhat addressed also in the previous panel, so I'll try to tiptoe around any instances in which that has been the case to not bore you with that. I'll start by taking you through publicly available data on the number of cases under the ECT and the types of energy investments that have proven most litigious. And as you may have already guessed and have seen from previous panels and discussions, those are renewable energy investments. I will attempt to trace the origin of those investments and what the cause of the subsequent disputes were. And to do that, I'll take you in particular through the measures taken by Spain, Italy, and the Czech Republic to attract renewable energy investments, as well as the reforms that they later took, and which gave rise to numerous claims against those countries. I will briefly address the main protections under the ECT for those cases and how the investors configured the cases and how subsequent tribunals have understood those protections to work. And I'll end my presentation just by briefly mentioning the European Commission's, one of the European Commission's proposals to reform the text of the ECT and what it means for future investments in, among others, renewable energy, for instance. So let's begin by going through some of the available data that we have on the Energy Charter Treaty. Now, according to the Energy Charter website, which is great, by the way, I encourage you all to visit, as of the 1st of June 2022, according to the information that the Energy Charter Secretariat is aware of, there are 150 total investment arbitration cases that were brought under the ECT. And the first case was AES against Hungary. That was registered in April of 2001. And in the 21 years since, that would average around 7 cases per year. But of course, that average is very misleading because the vast majority of the cases were brought after 2012. So that's 138 of those cases were registered after 2012. So we might wonder why the sudden peak of cases under 2012. So we may find a clue if we look at 3 of the ECT's most frequent offenders. These are Spain, sorry, Rafa, 51 claims against Spain, Italy with 13 claims against Spain. I won't mention Romania out of respect, and the Czech Republic with 6 claims. Now, these cases against these countries concern, for the most part, investments in renewable energy. And in fact, the majority of the claims that were brought under the ECT concern renewable energy investments. That's 81 out of the 150 concern renewable energy investments. So as we heard in the last panel, despite the criticisms that certain political groups have directed at the ECT, claiming that the treaty undermines international climate change commitments and prevents governments from implementing the legislative changes necessary to transition to a higher renewable energy output, the fact remains that, to date, the most protection that has been sought is on behalf of renewable energy investors who have seen the investment-inducing regulations being pulled out from under their feet. So, and what do these renewable energy investment treaty disputes, if anything, have in common? Now, it's maybe helpful to briefly go to the regulatory framework that applied in the early 2000s and the characteristics of renewable energy investments in general to see where the problem may arise. Now, just very briefly, because this was discussed earlier, in the 1990s was when finally the international community started to take action to combat climate change. So in 1992, you have the United Nations Framework Convention on Climate Change. That was followed by the Kyoto Protocol in 1997. But importantly, within the EU, you have the 2001 EU Directive on the promotion of renewable energy, which obliged member states to take steps to comply with the global indicative target within the EU of 12% of gross national energy consumption by 2010 that had to come from renewable energy sources. And that's 22% of total EC electricity by 2010. Now, those figures might not look like much today, but back in the day, they were very, very challenging. And they could only be achieved really by attracting significant private investment into the sector. And private investors at the time were very unwilling to invest in renewable energy because, as most of you will remember, the situation at the time was markedly different than it is today. And grid parity was a very long way off from what it is today, with renewable energy being significantly more expensive than conventional energy. And just to give you a sense of magnitude, from 2010 to 2020, for newly commissioned projects, the global weighted average levelized cost of energy of utility scale PV fell by 85%. So that's from USD cents per dollar of 38 cents per kilowatt hour to 5 cents per kilowatt hour. So 38 to 5. And this happened as the cumulative installed capacity for PV increased from around 40 gigawatts to 707 gigawatts. PV energy went from being twice as costly as the most expensive fossil fuel to being among the bottom of the range for new fossil fuel fired capacity. And so at the time, states had to attract investment, and the only way to do that is to provide incentives for these investments to be viable. Now, with renewable energy investments, more so than other energy investments, maybe, you have a very, very high initial capital investment. You set up the park, you set up the wind farm, you set up the PV plants, you install them, and you pretty much forget about them for the rest of the useful life. There's some maintenance involved, obviously, but 80% of the capital is up front. And so you have a very high moral hazard that the state will attract your investment, and then once it's captive, since you can't just take your panels and leave and set them up somewhere else, the state will take measures against you. And so the way to attract the investment, that which proved most effective, was through feed-in tariffs. And feed-in tariffs are simply fixed prices per unit of electricity fixed over the long term. That can be periods from 10, 15, 20 for the lifetime installation. Different regimes have figured out in different ways. And in particular, Italy, the Czech Republic, and Spain all implemented feed-in tariff schemes. Italy implemented successive schemes in 2005, 2007, 2010. These were the Conto Energia 1, 2, and 3 regimes. Common denominator was that the feed-in tariff was set for 20 years, and installations that qualified in subsequent years received lower tariffs as the cost of the technology was lowering over time. The Czech Republic implemented a feed-in tariff scheme called the Act on Promotion in 2005, and that, so it said, and so the government said at the time at least, guaranteed remuneration for renewable energy producers for 15 years. Now, I'll briefly touch upon Spain as well. My country implemented successive feed-in tariff schemes through successive royal decrees, particularly in 2004 and 2007. The common denominator also was that they provided a fixed incentive, either a fixed feed-in tariff for the entirety of the remuneration of the plant per kilowatt hour, or a premium on top of the market price for each of kilowatt hour as well. Now, importantly, the regulation provided that obviously changes would be made in the future as the cost of the technology was lower, but crucially, those changes would not affect installations that had qualified earlier and which did not have, obviously, the benefit of those lower costs, of technology costs. Now, once these regulations were implemented, that was not the end of the story. So the states actively promoted these regimes in order to seek out the objective which led them to implement them in the first place, to seek private investment. And they paid off very well. And in particular in Spain, we became the #1 country for a number of technologies worldwide. So sadly, that's the happy part of the story, and now is where that ends. The subsequent years, when these countries were faced with the energy bill and obviously with the high cost that renewable energy represents, the states changed the regulatory framework they had put in place to induce investment. Some changes were of more limited magnitude, but as we'll see, some of the changes were rather significant. So just briefly, the Czech Republic in December of 2010 introduced a solar levy for PV installations that had been registered in 2009 and 2010. That was of 26% of the installation's revenues. Italy first moved the goalposts in 2011 with regards to the term that an installation had to qualify for Conto Energia 3. Previously, an installation could qualify in 2011, and that was no problem. Then it set a hard cutoff date of May 31st. And so an installation that was maybe under development and which had all the necessary financing and a great part of the investment, but needed a few months to connect to the grid, suddenly saw that it was no longer in time to qualify. And then later in 2014, Italy directly took the feed-in tariffs of existing investments and reduced them contrary to what the previous regulation promised. Now for Spain, those changes were significantly more fundamental than those of the Czech Republic and Italy, which is maybe why there's been significant differences in the awards against Spain. Between 2012 and 2014, Spain simply just pulled the plug and changed the regime completely. At the end of the process, there was nothing left of the feed-in tariff regime, one with a fixed price per kilowatt hour of electricity, and it simply replaced that with a system where Spain, ex post facto, estimated what the efficient investment and operating costs should have been for investors investing a few years ago. That's, Spain with a crystal ball. and provided what it then deemed to be a reasonable return on those investments. And unsurprisingly, the effect of that was a significant reduction in the investors' revenues. Now, obviously, unsurprisingly, investors in these countries were unsurprisingly appalled, unsought relief under the ECT. And so what relief could they seek under the ECT, and what did they do? Broadly speaking, you have states' obligation to provide fair and equitable treatment under Article 10. It's not the only protection Article 10 provides, but it's the one which better fits this fact pattern that I just described. And you also have protection against expropriation in Article 13. But given that finding for indirect expropriation requires substantial deprivation in the value of the investment, and that is not always the case, investors have mainly based their claims in breaches of fair and equitable treatment. And even though it's not expressly worded in the current drafting of Article 10, an essential pillar of the fair and equitable treatment standard, at least as it's been argued by investors and as it's been upheld by case law, is that if the state's conduct creates reasonable and objectively justifiable expectations on the part of the investor, and an investor acts in reliance on such conduct, any breach by the state of those legitimate expectations would be in breach of the treaty and would thus entitle the investor to damages. Now, given the fact pattern of these cases, it's not really surprising that most are largely structured against breaches of expectations. So essentially, they follow the following narrative. So first, states were eager to attract investment. They knew the way to get it was through regulatory FITs that were guaranteed for the long term. And as the cost of the technology fell, feed-in tariffs would be lower, but only for future installations. The investors fell for this and therefore invested significant sums of money and allowed the states to reach their installed capacity objectives, on the basis of the specific commitment within the regulations that they would apply for a specific amount of time. And third, once the capital was deployed, these investors saw the state change them completely. States said, sorry, you're naive to think that we wouldn't change the regulations. It's not like politicians are known for keeping their word. And so these investors suffered harm. And so these investors then claim that these regulatory changes to the feed-in tariffs that had been promised are a breach of their legitimate expectations. Ultimately, this is a fact-specific inquiry by investment treaty tribunal. So, I've just mentioned broadly the renewable energy framework that had been put in place by each of these countries and the measures that they took. But obviously, when a tribunal has to look at a case like this, it has to do so case by case. As Rafa just said, they can't reproduce the parrot effect unless it's favorable for my clients, but they do have to look at it on a case by case basis. You have to look at the date of the investment. The investment climate is not the same throughout the entire lifetime of the feed-in tariff scheme. You have to look at what the regulation said in particular. You have to look at how the state actively or did not actively promote the schemes. You have to look at what was being said on the market at the time, and a subject for debate is to what extent is it relevant that the investor carried out due diligence or not, or whether or not the assessment has to be on an objective scale at what any other investor investing in that country under that framework would have understood, regardless of whether that particular investor had a regulatory due diligence report where the possibility of change of that regulation was explored. Now, obviously, the more radical the changes, the easier it is for a tribunal to find that there was a breach of legitimate expectations. Even, in the case of very clear expectations, it would be difficult for a tribunal to find that the state has breached the ECT when the changes are very piecemeal or where the value of the investments hasn't really suffered much. Now, let's now briefly look at the outcome of what these cases against Italy, the Czech Republic, and Spain, and what tribunals have done in those cases. So, unfortunately for investors in the Czech Republic, as far as I'm aware, the state has prevailed in every instance. None of the arbitral tribunals, in particular, when assessing the act of promotion in 2005, has found that regulatory framework to provide or to generate legitimate expectations on the part of the investor, and in particular the expectation that the feed-in tariff schemes would not be amended in the way that they were. So just to provide a few examples of decisions, you have in Antares, the tribunal ultimately found that the claimant was an opportunistic investor that should have known when they invested that the framework was in a state of flux. So here you see how crucial it is to analyze expectations as of the date of the investment. Possibly if that claimant had invested a few years earlier, the outcome would have been different, but we'll never know. And the tribunal then found that it would have been obvious to anyone that had discussions with industry associations or even read the press that the sector, renewable energy sector in the Czech Republic was in a bubble and that the state would have to intervene. Just another example of a decision in the Czech cases, you have ICW Europe Investments, where the tribunal more closely looked at the act on promotion and found that there was nothing there that said that the FIT would remain unchanged for the duration of a plant's operation, and it did not find any mentions of long-term guarantees and stable promotion of investment, which could lead investors to believe that the regulatory framework would not be amended. Now, notably, there's been Gary Bourne was on various of those tribunals, and he issued a number of very strongly worded dissenting opinions where he claimed the opposite. He claimed that he sustained very convincingly, in my view, that the terms of the Czech regime were very clear, as were the actions of the Czech government and the intention of the regulations that were to seek investment, and that obviously the measures that the Czech Republic then took was a clear breach of those expectations. Now, investors in Italy were more fortunate. As far as I'm aware, they've prevailed in green tech energy, where they were awarded 11.9 million in damages out of approximately 25 million that they claimed. In the SPF Beteiligungs, where they were awarded 16 million out of approximately 28 million claimed, and in CEF Energia, where they were awarded 9.6 million out of 10.3 million that were claimed. And just by way of example, in the green tech case, the tribunal analyzed the Conto Energia 3 regime and found that, the claimants had been led to believe that the FITs in that scheme would remain in place throughout the entire 20-year period. And they also found that Italy had not provided a persuasive reason to conclude why investors should not have expected that the feed-in tariff schemes would remain constant. And now, notably, the tribunal found that while investors might have to live with minor adjustments, but nothing alerted the claimants that the magnitude of the changes would be as high as those implemented by the measures in dispute in that case. Now, in the Spanish cases, sadly for my country, investors have largely prevailed. It helps, of course, that Spain's measures were so significant. To date, as far as I'm aware, 30 tribunals have rendered decisions on jurisdiction and liability. Of those, Spain has prevailed in 5 cases. That's Sharan, Isolux, Stadtwerke Munich, and others, FRIFE, and CSP Equity, with Spain being found liable of breaching the FET standard in the remaining 25 cases. But notably, there's been 2 broad trends of decisions based on the tribunal's assessment of the claimant's expectations and the commitments contained in the Spanish FIT framework. One trend finds that the framework could be taken at face value and generated the legitimate expectation that the feed-in tariff schemes would apply as promised for the entire useful life of the installations. But the other trend finds that the only expectation that investors could have was that of a reasonable rate of return, whatever that is. The trends are pretty much evenly split. The first trend would be represented by awards in ISER, Nova Energia, Antan, Masdar, Watkins, to name a few. And the second trend was inaugurated by the Reef Tribunal in November 2018, and has since been followed by more tribunals than I would have liked. And so, broadly speaking, just by looking at what tribunals have done in these cases, one could say that the ECT has proven an effective instrument to protect investors in at least the most flagrant and striking cases. Now, the next step of the ways to get paid, of course, none of the investors, as far as I'm aware, have seen any money, and that's, in our view, a real problem, because it's not really very useful to bring these multi-million-dollar cases that cost also multi-million of euros or dollars in fees if the client then at the end of the day is not going to see a penny, and they can just hang the award on his wall, and really the issue is whether or not these states will effectively pay. The Antan Award, for instance, is from June of 2018, and 4 years later, nothing has happened, and the investors remain unpaid. Now, of course, what this means is there's this parallel market, second-hand market of awards where they're being sold as discounts, and people are speculating as to what price they should assign to these awards based on the fact that the state is not paying. Of course, if the state paid, this wouldn't happen, and there would be no secondary market, because nobody would sell their awards at a discount if they knew they were going to be paid tomorrow, as they should be. But anyways, before I give the floor to Graham, welcome Graham, let me just mention that one of the changes that the EC has proposed to the ECT, before Graham addresses the matter in significantly more detail. Now, the EC basically, among other things, proposes language around the ECT to allow states for more regulatory leeway without breaching their commitments. And in particular, under a new Section 3 of Article 13 on expropriation, the EC proposes to add the following language. It would allow non-discriminatory measures by a party that are designed and applied to protect legitimate policy objectives, such as the protection of the environment, public health, etc. Now, as you'll notice, this is a very broad formulation that would clearly allow states a way out, should they suddenly have second thoughts about the investment-inducing measures that they took. And it also allow measures a way out, as was discussed also in the previous panel, should they suddenly want to change the regulatory framework applicable to fossil fuels, or bring about a significantly higher renewable energy output without having to pay the bill. And this would have the effect of watering down ECT protections, in my view, and it's not particularly advisable. Curiously, the EC has not provided similar language to Article 10, but that may have just been oversight or the fact that the proposal is still in very draft form, with the language, I assume, being meant to apply to both standards. And with that, I conclude my presentation and give the floor to the next speaker.
Thank you very much. Before doing so, I have 2 notes and 1 question. Yes, you're right. The fact that the states are not paying probably first activates the secondary market. Secondly, although we still see intra-EU ECT cases, from a practical perspective, I note it is much more difficult to obtain third-party funding for intra-EU ECT cases. And the second note is, and here I'm looking at the organizer, maybe at the Bucharest Arbitration Days 2023, we will get the opportunity to analyze the first arbitral award in a claim, in a renewable energy claim against Romania, and then maybe expand, go local with the analysis as well. And the question is now, intra-EU objections, right? We are 60-0 now. What's your take of Rafael's "e pur si muove"?
Well, my take is significantly more investor friendly, as you may not be surprised to hear. I would be very surprised to see arbitral tribunals upholding the intra-EU objection. Frankly speaking, I just don't see how it's possible that a tribunal will uphold it, given the wording of the ECT and the arguments that are being brought forth to date on the matter. I mean, Rafa mentioned, the parrot effect and how tribunals have made a mistake, for instance, with the disconnection clause. But from experience, I've read many of these awards provide differing reasons, and many of them are very convincing. Recently, I've read an award where Professor Schroyer was on the tribunal, and he pretty much hit the nail on the coffin. And I'd say it's the matter is pretty consolidated, and so hopefully it'll stay that way.
Thank you. And now moving over to Graham. Graham is a partner with Volterra Fietta and former General Counsel of the Energy Charter Secretariat in the UK. And Graham is going to tell us about the modernization of the Energy Charter Treaty, a treaty for 2020 and beyond. Please.
Good afternoon, everyone. Thank you, Sebastian, for that optimistic introduction. Thank you also to Krina, to Cosmin, and to numerous others who have helped put this event together and for inviting me to participate. My humblest apologies for arriving late for the start of my panel, which is entirely due to a misunderstanding on my part as to when my panel was to take place. For some reason, I thought it was in the afternoon, but I'm very pleased to be here with you all. Just one small correction before I start to Sebastian's very kind introduction. Although Volterra Fietta is in the UK, the Energy Charter Secretariat is in Brussels, where it has been, and this is not your fault, I can see it's on the sign as well, where it was deliberately created to be under the wing, so to speak, and under the close supervision of the European Commission and the other European institutions. So, the modernization of the Energy Charter Treaty. It's indeed a fascinating and highly relevant topic. And numerous proposals have been made for the treaty's modernization. This started in 2010, when I was still General Counsel to the Energy Charter. The Energy Charter Secretariat are very optimistic. They're paid to be optimistic. I was paid to be optimistic for 7 years, and I genuinely was optimistic. Today, I think we can say, those of us who aren't paid to be optimistic, that the outlook is perhaps a little more mixed. However, before I go into the different proposals for modernization of the ECT, perhaps it would be helpful to give a little bit of background, and apologies to the majority of you who are probably already familiar with this. But for those who don't know, the Energy Charter Treaty was negotiated between 1990 and 94 and signed in December 1994. And naturally, as with all historic treaties, its text reflects the issues which were to the forefront of public opinion and concern at that time. At that time, the USSR had recently broken up. A number of Central and Eastern and Southeastern European countries, we had an interesting discussion about Central and Southeastern European terminology over dinner last night. A number of these countries were looking forward to a future, possibly in the European Union, and certainly a future with a more Western liberal free market approach to developing their economies, as were indeed some of the other former member states of the former USSR at that time. There were huge energy reserves, still are of course, in Russia and other former CIS member states. At that time it was thought that the natural market for those energy reserves was the developed economies of Western Europe. Today, of course, China would have a different view on this topic, but at that time that seemed to be the natural approach. And so one of the main objectives of the Energy Charter Treaty was to foster and encourage the development of these enormous energy reserves and their transport to what was seen as their natural market in Western Europe, which meant that the main focus of the Energy Charter Treaty was on encouraging investment promotion and investment protection, including in relation to transit, and there's a very sophisticated provision on transit in the Energy Charter Treaty, not perfect, but far more developed than anything that had preceded it in, for example, the GATT and WTO agreements. And it's important to remember, too, that the Energy Charter Treaty isn't only about investment protection, even though that is the main focus of today's and yesterday's conference. It does cover transit and energy efficiency as well. In any event, this treaty was negotiated in the 1990s and signed in 1994, and has not been amended since, save that there has been a trade amendment which was uncontroversial and which brought the Energy Charter Treaty's trade provisions in line with those of the WTO agreement, which came into force in, I believe, 1995. So we fast forward 30 years almost, and we see that there are many arguments about the current effects of the treaty and the extent to which the treaty is relevant to the world's political, economic, and environmental agenda in the 2020s. And so there have been many proposals for the treaty's modernization or reform or improvement. There have also been a lot of myths, I'm sorry to say, propagated about the Energy Charter Treaty. There is the myth that the Energy Charter Treaty specifically encourages fossil fuels at the expense of renewables and other less polluting forms of energy. I'll deal with that in more detail in a minute. There's also the myth that the Energy Charter Treaty favours investors unconditionally at the expense of states. And for example, it's been alleged that a state has only to take a single measure which reduces an investor's expected profitability, and that gives the investor the right to bring a case against that state and to win. And of course, it does give the investor a right to bring a case. We can all bring a case against our neighbours, our employers, our landlords if we want. It doesn't necessarily mean that we will win, but we have the right to have our day in court. The fact that we can bring a case unfairly is not in itself a criticism of the court system. And of course, the same is true of international arbitration. Nonetheless, there have also been some other proposals for modernization of the treaty, which have a little more factual basis. And my task today is to take you through some of these proposals. And of course, it's necessarily brief because the proposals themselves are very detailed. And then perhaps to spend a few minutes at the end of my presentation talking about the potential ways forward, how these proposals could actually be implemented, and what options are on the table in case these proposals are not ultimately accepted. So, the different proposals for modernization of the Energy Charter Treaty fall into more or less three or four main categories. There are those which relate to jurisdiction, and in that category I put sort of two subcategories. I put those that cover the scope of coverage, which investments are in fact protected by the Energy Charter Treaty, because as you all know, I'm sure, the ECT does not cover all investments by an investor from one member state in the territory of another member state, but only those that relate to the energy sector. So there's a scope of coverage. Then there's the substantive protection standard in fact applied, and Pablo's already made some reference to this in its discussion of the fair and equitable treatment standard, the right to regulate. And then there are other issues of jurisdiction and procedure which are extremely important in the context of many investment arbitration claims. So those are the three main categories that I'd like to cover today, and if anybody wants more detailed information, I'd invite you to refer to the Energy Charter website, which used to be ncharter.org. Today I think it's changed its name, but ncharter.org will still get you there. I'm a bit too lazy to remember the new name every time I type it in, where all sorts of proposals have been posted. And of course, as I said, the postings on this website are optimistic. So if you also search Energy Charter modernization in general, then you get slightly less optimistic comments from the European Commission and various EU member states, as well as far more pessimistic comments from various NGOs. So in terms of the scope of sectoral coverage, there was some preliminary discussion about the definition of an investment, because as people here will know, many tribunals have interpreted this definition extremely widely and have included every kind of asset without any other tests than the fact that this is an asset and that it actually has a commercial value. Then we have the Salini criteria, which certain tribunals, but not all, have followed, which include a certain duration, the expectation of gain, the assumption of risk, the injection of capital into the host economy, and so forth. Tribunals sitting under the Energy Charter Treaty have differed in whether they've accepted the Salini criteria or not. And one of the proposed reforms is that investment should be redefined. Investment as defined in Article 1.6 of the treaty should be redefined so that it would cover every kind of an asset that an investor owns or controls directly or indirectly that has the characteristics of an investment, which, as the proposed provision goes on to say, include a certain duration and other characteristics such as the commitment of capital or other resources, the expectation of gain or profit, or the assumption of risk. So there you have a clear writing into the definition in the treaty of the Salini criteria, or something very like them. Now, beyond that, there's also been a substantial debate about the scope of sectoral coverage, exactly what kind of investments should be covered. And in that context, as I said, there have been some myths about the ECT. It has been stated that the ECT only covers fossil fuel investments because those were the only kind of energy-related investments that were really a significant economic factor at the time the treaty was negotiated and signed. Now, that latter proposition may be true. It may be that wind energy, solar energy, and so forth, and hydrogen were not significant economic factors. Scientists knew about them, but they weren't really an economic factor in the early 1990s. However, there is nothing in the text of the ECT that specifically excludes these investments, and indeed, electricity is specifically covered, as are facilities for the production of electricity, which means that renewable projects whose purpose is to produce electricity, which of course is the case with the vast majority of wind and solar renewable projects, are in fact covered by the Energy Charter Treaty, contrary to some of the more extreme assertions made by the propagators of these myths. There are still some respects in which the treaty could be improved in this respect. Hydrogen, for example, is a gas which can be burned so as to create energy, and of course to create it you need to invest the energy from some other form. Hydrogen is not specifically referred to in the list of covered energy materials and products in the annex to the treaty. It could be argued that it is covered on the basis that it is a gas analogous to natural gas, and there are references to similar gases or to coal gas. It could also be covered on the basis that it is effectively a derivative or a means of transmission of energy from other covered sources, but then that, of course, would depend on which form of hydrogen we're considering. I'm no expert, but I realize that there's green hydrogen, blue hydrogen, grey hydrogen, which all come from different methods of production. And so it's certainly arguable that the treaty could be improved, or if it were negotiated today, very likely would include a specific reference to hydrogen. Same kind of considerations with respect to carbon capture and storage, where we have many energy-related projects whose specific purpose is not actually to create more energy or to create energy more efficiently, but to minimize the polluting consequences of energy production by capturing CO2 and then storing CO2. CO2, of course, is not in itself a form of energy, except perhaps to the extent that it's to be found in energetic drinks. However, once again, this could arguably be covered by extending the list of energy materials and products to include CO2. It would be what we call a legal fiction. Of course, whether that would have the side effects of including energetic drinks under the ECT is another issue. But at any rate, we could include CO2, and perhaps if it were to do again today, we would include CO2, or at least carbon capture and storage technology, in the list of energy materials and products covered by the treaty. In any event, the provisions for changing the scope of covered investments very broadly include two categories. One, extending them explicitly so as to cover these forms of energy which I've just discussed, which were not specifically explicitly covered when the treaty was first negotiated in the 1990s. And two, removing protection of fossil fuel energy from the coverage of the treaty. Now, that is quite a far-reaching step, and various arguments have been made in favor of this. One argument is that the treaty as currently drafted gives fossil fuel producers or transformers the ability to sue any ECT member state which takes any action to protect the environment or to implement its obligations under the Paris Treaty, which harms the profitability of their fossil fuel investments. And we discussed this for a few minutes already. As Pablo's very capably explained, it's a matter of factual appreciation in each case, whether the changes actually have the effect of creating a violation of fair and equitable treatment or an indirect expropriation or not. It's not that the investor wins every time. And the other argument that's been made is that fossil fuel investment is basically a bad thing and therefore should not be protected per se. Now, in answer to that, I would say that even if a particular kind of investment is a bad thing, it does not follow that for a state to expropriate that investment is necessarily not also a bad thing. And there's a difference between taking measures to restrict certain kinds of technology on one hand and taking measures to simply expropriate the facility and carry on the production for oneself on the other. At any rate, it's been proposed that coal, natural gas, petroleum, and petroleum products should be deleted from the scope of sectoral coverage. This proposal is very popular. It tends to be more popular the further west you go. It's quite popular in the Netherlands, in France, in Germany, not so popular in Central and Eastern Europe, and not popular at all in strong oil producing or oil or gas producing or oil or gas transmitting countries such as the Stans, the former Soviet republics, the former CIS states. And so various compromises have been discussed. One compromise which I believe the Commission put forward was that every member state should be free to decide for itself whether to remove fossil fuel projects in its territory from protection of the ECT or not, so that the European Union would be free to remove such protection. The non-EU countries which depend on fossil fuel production to a greater extent would be free to maintain it in order to continue to attract investment. Another proposal was that there should be a staged or timed approach, so that after a certain number of years, certain kinds of projects should be unprotected. Coal projects first, then oil projects, followed by gas projects with a longer sunset clause, if you will, for gas projects that achieve a certain minimum level of efficiency and also a certain minimum level of carbon capture and storage. So these are the different proposals that have been made. And the current proposal on the table is, I think, in the last category that I mentioned. The fossil fuel coverage will be removed in stages. Different member states will be given the right not to remove it at all, but to keep it, while coverage will be retained for renewable energy, for electricity in general, including nuclear electricity, and for hydrogen. Moving then from the definition of the types of projects covered by the ECT to the actual substantive protection standard. And here I'll try to be quite rapid because Pablo and quite possibly previous speakers have already covered this to a significant extent. As Pablo said, there is indeed a proposed change to the right to regulate, or rather to the relationship between the right to regulate and the current substantive protections in Article 10 of the ECT, so that there's a specific new provision on regulatory measures which is intended to make it clear that contracting parties retain the right to regulate within their territories to achieve legitimate policy objectives, such as protection of the environment, including combating climate change, and then there's a whole host of other objectives that are also legitimate. It's provided that this should not be interpreted as a commitment from a contracting party that it will not change the legal and regulatory framework, including in a manner that may negatively affect the operation of investments or the investor's expectation of products, and a decision not to issue, renew, or maintain a subsidy in the absence of any specific commitment under law or contract to issue, renew, or maintain that subsidy. So it reverses the burden of proof in a sense. And also, that it should not prevent a contracting party from requesting the reimbursement of a subsidy where such action is necessary to comply with obligations imposed on the contracting party by an international agreement establishing a regional economic integration organization, which basically means the European Union. In other words, if you receive a subsidy and then the European Union in its wisdom decides that that constituted illegal state aid and must be recuperated, the Energy Charter Treaty cannot be a bar to its recuperation. So that would put an end to cases such as the Mikula case against Romania, were that a case relating to the Energy Charter, to the energy sector. So priority is given to the right to regulate for specific reasons and to European Union state aid rules. Beyond that, the definition of fair and equitable treatment itself and the other protections provided in Article 10.1 are substantially scaled back. fair and equitable treatment is exhaustively and limitatively defined by examples, including, for example, denial of justice, breach of due process, manifest arbitrariness, and discrimination and abuse of treatment. Constant protection security is defined so as to include physical security only. Quite a few tribunals had previously interpreted this as also including legal or contractual security. The relationship between expropriation and the right to regulate is clarified in the sense that the right to regulate clearly takes precedence and regulation does not constitute expropriation per se. Restrictions on transfers of capital and so forth are permitted in exceptional circumstances, so that's intended to address some other post-1994 events such as the 2008 financial crisis and possibly other situations that might require temporary capital controls. And there's a specific article on sustainable development which includes many things, including multilateral agreements, clean energy transition, responsible business practices, transparency, and impact assessment, which are all declared to be important objectives too. So following that extremely brief summary of the changes to the substantive protection scope of the Energy Charter Treaty, I now move to deal briefly with a few jurisdictional and procedural points. The ECT contains, as many of you will know, a most favoured nation clause, which in the past has been interpreted quite extensively, including in relation to procedural issues and theoretical comparisons. I mean, if you're from State A and your investments in State B, and State B's concluded a different treaty with State C, then you used to be able to point to a different provision in that different treaty and say, well, that's more favourable than what I've got, so I want that to apply to me as well. Under the proposed reform, it's no longer going to be possible to do that. You have to actually point to a specific factual example of more favourable treatment to a particular investor. Denial of benefits, there's been a line of jurisprudence that makes it clear that, generally makes it clear that a host state must give prior notice if it intends to invoke Article 17.1 of the treaty allowing it to deny benefits to mailbox companies. Now it's made clear under the reforms that no prior notice is required. There's a couple of jurisdictional provisions that try to give jurisdiction to the Multilateral Investment Court, which the European Commission has proposed over recent years. There's provisions to reject frivolous claims in very short order, requiring the source of any third-party funding to be disclosed, and specifically permitting third-party interventions. Once again, very likely the European Commission has an eye upon the numerous interventions that it's made over the years in various intra-EU investment treaty cases. So having concluded that rapid review of the jurisdictional and procedural proposals, I'd simply like to spend a few minutes looking at what could actually be done with these proposals, if I have time, Sebastian. Or would you like to leave that to the bit later?
We need to wrap up a little bit and then leave a little bit of...
Okay.
No, please.
Okay, sure.
Use the next 2 minutes to wrap up, please.
In 2 minutes. As I've explained already, these different proposals have elicited many different opinions. Amending the Energy Charter Treaty requires unanimous consent of its contracting parties. At least that doesn't mean they all have to ratify it and become bound by it, but it has to be approved at a conference where no contracting party votes against it. At the moment, Japan is opposed to any change to the Energy Charter Treaty. Other states have very serious reservations about most of the proposed changes in practice. Even within the EU, there is not unanimity. What happens if the states can't agree to amend the Energy Charter Treaty unanimously? Some states could pass a protocol among themselves, but that would only bind them. It wouldn't apply to others. States could withdraw from the Energy Charter Treaty. That's provided for in Article 47, I believe. This would bring in a sunset clause. The European Commission has proposed that all its member states, if they can't get the non-EU member states to agree on their reform proposals, should stage a coordinated withdrawal, but that would leave both the European Union itself and all of its member states subject to a 20-year sunset clause in relation to claims based on future actions in relation to pre-existing investments. So to end, there is in fact a recent announcement on the Energy Charter website saying that very substantial progress has been made in the negotiations and looking forward to their conclusion at wrap-up meetings in June and July. But there are also, unfortunately, conflicting statements from various EU member states which give the contrary view. So perhaps as the way to finalise before our lunch break, basically everyone can form their own opinion about how optimistic the chances of the Energy Charter Treaty's successful modernisation and reform are, or not, as the case might be. Thanks for your indulgence, Sebastian.
Thank you very much, Graham. Now, moving to procedural points. First of all, I didn't really get to give you the opportunity to raise questions to our panelists. So if any, please do so. Yes, please. We need
I think he's okay.
Thank you very much. It was very interesting. Two questions on my side, but we can prioritize one, and then, of course, if there are no more questions. Multi-party arbitration under ECT, what's your take under the current state of things? And if there's also a matter of modernization of the ECT Charter Treaty in regard to multi-party?
question goes to?
Everyone.
Okay, to volunteers, please.
Multi-party in the sense of multiple claimants in the same claim?
Yeah.
Well, you have the PV investors case where you had 14 different investor groups unrelated to one another with 14 different sets of investments in the Spanish renewable energy sector, which brought the claim against Spain under the ECT, and in particular was an ad hoc arbitration under the UNCITRAL rules managed by the PCA. So clearly the ECT allows it. Other cases had obviously multiple claimants, but they were all related to the same investment. But that's, you know, an outlier in that sense, and so pretty cutting edge case, if I may say so.
Any other views?
I can just echo what Pablo has said. It's perfectly feasible, and we have even faced claims based on the same treaty by claimants from different nationalities. At the end of the day, it's more job. So because you have to analyze the particular circumstances of each one, but it's perfectly feasible, and we have precedents about that. So
I would just say that the treaty could arguably, on a highly formalistic interpretation, as reference to disputes between a contracting party and investors from another contracting party. You could argue that at least multiple nationalities and of claimants or respondents are not permitted. If the claimants, in fact, choose to effectively waive this by getting together in the way you've described, then arguably that's their right. I think it'd be a bit more complicated if one claimant or several claimants wanted to bring a case against multiple respondents. I think in that case, the respondents could certainly argue that each of them should have its own right, for example, to appoint its own arbitrator. And many of you, even with fewer grey hairs than I, would remember the Dutco jurisprudence from France back in the 1990s, I think, where one claimant brought a commercial arbitration against more than one respondent. The respondents couldn't agree on an arbitrator. The court eventually appointed an arbitrator on behalf of the collective respondents, and they then successfully argued that their procedural rights have been infringed, even though they could have solved the problem by agreeing among themselves, and that was upheld. So I would certainly think twice before launching a case on behalf of a single investor against multiple respondents, unless perhaps it was the European Union itself and one of its member states, and it wasn't clear which was actually responsible for the measure being complained of. In that case, it might make sense to bring them both in.
Thank you very much.
I mean, you know my position, so.
Yeah.
Any follow-up to this one?
Yes, thank you. So the second question is related to, and it's more of a policy type of question. You are all international arbitration practitioners, but I was wondering if, you know, for a moment you could put the policy-making hat, which some of you had in the past. Renewables energy, renewables, you know, they are in this phase of continuous flux of innovation, and some of the support schemes or some of the incentives that the governments in the past have prepared for investors, in general, they are transferred to the consumers to the taxpayers. And looking, you know, in investments, and we discussed yesterday, investments in energy, generally they tend to take 20, 30 years, which is also sort of an important aspect for the investors, but also for the state, because in those 20, 30 years, a lot of things will change. So I was wondering, from lessons learned from Spain, Czech Republic, if you would, you know, advise the policymakers on some sort of actions to be taken when they want to regulate in this space.
Yes, I'd say careful what you promise. There's a very good example of that in Spain, actually. There's a royal decree, the famous 661/2007, that gave rise to most of the claims being brought up in Spain. And, you know, one could say that it set the tariffs very, very high and attracted a lot of investment into the sector, with the issue that it had significant holes in it that did not allow the state to modify the legislation in time should the costs of energy be significantly reduced. And with this, I mean, this regulation is from May 2007, and it had a mechanism whereby you had, as given installed capacity target for a given technology, and the state could only change the regulation and lower the FIT for new installations once 85% of that target had been reached, and then it had to wait for another year. So obviously, if it did not set the capacity targets right, if it did not set the level right, you could find yourself with a target of 400 megawatts, as it was the case for PV, for instance, and then with 4,000 megawatts of PV being installed, and with the state finding itself with a much larger bill than it had anticipated. And so I think the way to go is a system similar to the one in Germany, and which was implemented by Spain in September of 2008 in the subsequent regulation, which was a system that obviously set feed-in tariff schemes for the long term, but what it did was it offered a price based on demand. It saw what the demand was in the market, and if lots of investors were coming in, it lowered the price. And if investors were still coming in, it lowered the price again for each quarterly call for the long term for that installation. But it had to be a much more flexible system whereby the state was guaranteed to be paying the lowest minimum price to get the renewable energy installed capacity that it wanted.
Would you still involve the Commission in policy making at national level?
Only a quick one. If it's a longer one, then you have to take it over lunch, because organizers are going to.
No, I'm just going to say that I don't really trust the Commission that much.
In fairness, we should 30 seconds.
No, it's not. I think that sometimes we criticize a lot the European Union, so we have to keep in mind that the European Union has kept peace in Europe for the last 60 years, economic growth, and we have to take things a little bit serious. Apart of that, and the positive note, let's meet in 2 years and let's see if and yet it moves or not. Because I'm completely sure that sooner or later, one arbitral tribunal is going to uphold the intra-EU objection. And we have to keep in mind that exit tribunals feel a little bit, let's say, protected because the annulment, because the self-contained exit system. But French courts have already annulled awards due to constroy doctrine. It's going to happen for sure in Sweden, and with the PCA, those that are based on an EU member state, that have their seat on an EU member state, those courts who are going to know about the annulment, it's likely that they will follow the constroy doctrine. So this is annulment, and by courts. But my point is that what no arbitrator in the world wants is that his awards are annulled. And at some point, we will, I don't say that it's positive or it's negative, because I'm talking here in a neutral way. But at some point, it's a little bit naive to think that we're not going to see arbitral tribunals upholding the intra-EU objection. That's my point, but let's keep it open and let's meet in 2 years, and I invite to, we can bet, in fact.
And see the prediction. I take your word, 2 years. And with this one, thank you very much. I will ask you to join us in an applause for our wonderful panelists.
Good afternoon. Good afternoon, everybody, and thank you for joining us today, both in person and online, for the final panel at Bucharest Arbitration Days titled Sustainability and Climate Change Disputes, or as we lovingly call it, the graveyard shift, because as you know, given that it is the final panel, it is even more challenging to keep your attention, but with a very, very lively presentation from our distinguished speakers, we are sure that that will happen. Before we turn to introducing our panelists, we would like to just give you some background about YRAP, which is the Young Romanian Arbitration Practitioners Group, of which both myself and my colleague, Diana Ichimescu, also a YRAP board member, we are part of. YRAP was founded last year to be a group for Romanian practitioners, both based at home and abroad, that are interested in international arbitration or practice it. We have several ongoing projects that I would like to flag, and just to give you a snippet of what we have on our plate. There is a mentoring program that we are coordinating, also a task force on environmental sustainability, and also an event which will take place on 6th of October in person in Bucharest on arbitration and technology, which we recommend that you attend if you are in Bucharest. If you'd like to find out more about YRAP, we have a LinkedIn page, and we will also launch our website formally shortly, and we will also be around, of course, after the conference if you have any questions. Without further ado, I give the floor to Diana so she can introduce our distinguished panelists.
Thank you. I'm very pleased and honored to be here with these fantastic speakers. I will start with Lavinia. Lavinia is an international energy regulator expert currently working at a major energy infrastructure project in the EU. She has previously worked for European Agency for the Cooperation of Energy Regulators, as well as in academia, Florence School of Regulation, European University Institute, and in the private sector. Matej is the head of global project disputes in continental Europe, Fresh Fields, France, and Emirates. Matej focuses on commercial and investment treaty arbitrations arising out of global projects, including infrastructure, energy, industrial, and urban development projects. Matej has particular expertise in Europe and in the Middle East. Going on with Krina. Krina is an associate professor in international arbitration at Stockholm University and also a co-director of the International Commercial Arbitration Law, LLM. She has extensive experience, as you all know, in international commercial and investment arbitration, international dispute resolution, private and public international law. She has been involved in international arbitration for more than 70 years as counsel, arbitrator, and head of arbitration and mediation institution at AmCham Brazil Arbitration and Mediation Center. Today, we propose to tackle two themes. The first theme would be current policy perspectives at EU level, which are meant to accelerate the take-up of sustainable energy. And the second theme is climate change actions and sustainability, and going green. I will start with Lavinia. Thank you for being here. We have heard these days about the Repower EU plan. Oh, I'm deeply sorry. Thomas, of course, is a counsel and arbitrator at Vail Dispute Resolution UK. Thomas acts for both states and investors in investment treaty arbitration. In particular, this includes claims under the ICSID and UNCITRAL rules, bilateral investment treaties, and public international law. He has particular experience of the natural resources and financial services industry. Thank you, Thomas, and apologies. So, Lavinia, we have heard these days about the Repower EU plan presented by the European Commission recently, with a view to transition away Europe from Russian fossil fuels. In parallel, the European Green Deal also aims to set the blueprint for turning the EU into the first climate-neutral continent by 2050. In your experience as energy regulator expert, what do you think that are the most urgent actions under these policies, and what should be the priorities for EU member states?
Thank you so much, Diana. And thank you so much for inviting me and for having me here. I'm a little bit nervous, I have to say. So if you're going to hear my voice trembling, you're going to know it's because of that. But I learned at a public speaking course that if you say this to the audience in the beginning, then it's going to be a little bit better, at least for me. So in terms of the Repower EU, we have heard quite a lot of discussion about this in the past 2 days. So maybe because we are the final panel, we can do a bit of a recap, so that then we have, you know, some of the main issues, fresh in our minds after this conference is going to end. The Repower EU, as you said, is basically the plan of the European Commission to, if you want, on the one hand, in an affordable and also steady way, move us away from dependency on Russian fossil fuels, and also, on the other hand, to accelerate the energy transition. And this plan of the European Commission is basically building on the targets and on the ambitions of the EU Green Deal, which was issued in 2019, and is supposed to be done through the implementation of all these legislative proposals that exist under something called Fit for 55 package. The European Commission basically wants us to move away from Russian fossil fuels whilst preserving this utmost goal of having minus 55% greenhouse gases reduction by 2030 and to reach, if you want, the net zero emissions by 2050. In the Repower EU, we have certain types of measures that the Commission is implementing. On the one hand, we have the short-term ones, mid-term ones, and also long-term measures. And these measures refer to certain topics that will have to basically be implemented at the level of the member state, through either changes in the regulation, through changes in policies, through, if you want, advertising campaigns done by the member states to raise awareness on climate change necessities, and also independency from the Russian fossil fuels. Basically, the idea would be from the European Commission to ensure that on the one hand we do energy savings at the level of the EU and at the level of the member states, that we diversify the supply sources and also the import routes in the EU, that we ramp up hydrogen production and also biomethane, and also that we manage to, if you want, have some sort of backup plans and to be prepared for what can happen, because maybe such a situation like the one that is happening right now could not have been foreseen by anyone. And so this is was one of the, if you want, triggers for the Commission to start asking and demanding the member states to update their contingency plans and to think, okay, what are actually the non-protected consumers that you will curtail in the situation of a supply disruption, major supply disruption. And last but not least, I think the most important, a very, very important part is the workforce and the upskilling and reskilling of the workforce, because in the end, without people that are very well trained, then we cannot do anything. The energy transition will be delayed, the Repower EU goals will not be achieved, so therefore a lot of money will be invested, if you want, and funded by the European Commission through various opportunities to the reskilling, upskilling of the workforce. If we go to break them down a little bit in terms of what exactly can happen at the level of the member states, instead in what concerns the energy savings, I think all of us can have a part. And according to the European Commission and the International Energy Agency, what we can do is to, I don't know, sometimes maybe turn off the lights, maybe take the public transportation, maybe turn down the heating in our house, drive more economically, because we know, for example, in Romania, we like to drive a little bit fast on the roads. So maybe we can do that in order to help to reach this demand reduction goal. And according to the Commission, if we all contribute to that, and if we also have the member states that do some sort of awareness, public awareness campaigns, and if we have reduction, if you want, in you know, some incentive, fiscal incentives to the household consumers to kind of like have energy savings in their households, then this can actually help us if you want, reduce the dependency from Russian fossil fuels with 10-13%, which is quite a huge number by 2030, of course. In terms of, if you want, diversifying the supplies, the Commission wants to, on the one hand, create this EU energy platform that the Professor Cameron actually discussed about at length yesterday, to pool demand and to make sure that they manage to buy the LNG and the pipeline gas to ensure security of supply in the EU. But at the same time, then they are also ensuring a lot of investments to ramp up the hydrogen sector, hydrogen production. For example, in this situation on the Repower EU, they have upgraded doubled the goal to produce hydrogen, green hydrogen in the EU from 5 million tons to 10 million tons produced internally, which is a huge number and which, in order to be produced, needs a lot of investments in electrolyzers. Which also needs a clear, if you want, regulatory framework. Moreover, to diversify supplies, what can be done, and diversify supplies in terms of major deployment of renewable energy production capacities. The Commission, through the Repower EU, says, I want this time renewable energy to be something called public overriding interest, which means that the member states will have to update their national legislative frameworks and give, if you want, speedy permitting conditions for the wind and solar projects. At the moment, if you want to, medium time to have a solar or wind power plant functioning. For the wind, 9 years, for the solar, 4 years, but this is not steady across the member states. So therefore, the member states want to have some sort of one-stop shop where the project can go, they can get all the permits, and this can actually happen within a very short period of time. So this is one of the very important topics from this Repower EU. And then we have the increase in biomethane production, up to which has not really been done until now. Which promises to also ensure independency from Russian fossil fuels up to 35 BCMs by 2030, which is again a very big number. If we move on to preparedness, the member states will be requested to update these preventive and preparedness plans to make sure that in case of a supply disruption, then they know exactly who to curtail, not the protected customers. And also the Commission has put forward some sort of an idea of a EU gas price cap, which probably will be quite challenged, or maybe not. Maybe if the member states agree to work together and to have a EU gas price cap in case of a supply disruption, then this might fly. In other situations, it might not. Maybe the member states will decide to just close down their borders and to use their energy for their consumers. In terms of preparedness, I think there's also a lot of investment in the infrastructure to transport the energy from production to supply and to make sure we have enough import corridors in the EU for the hydrogen to bring it from abroad, and also enough LNG terminals to make sure that the gas and in the future the hydrogen will get to the production, to the consumption, sorry. And I think last but not least, it would be also if you want, worth it to talk a little bit about the national recovery and resilience plans that have been approved already by the European Commission, but now through the Repower EU, each of the member states will have to include a chapter in these recovery and resilience plans, talking about Repower EU, and whereby a large part of the investments can be moved towards renewable energy infrastructure and also towards upgrading, if you want, the infrastructure that already exists to make sure we can transport the gas, the LNG, the hydrogen within the European Union. Romania also has such a plan. It has been approved by the European Commission in 2021, but now I think with an amount of 29.2 billion. But now there is also the possibility to insert another chapter and to maybe get more money for the investments in the infrastructures. Last but not least, I go back to the upscaling and the upgrading of the skill of the workforce. there is money for that, and it would be very nice to see that at the level of the member states they would actually use it to reskill the workers. In Romania we do need that. We have a huge region which is basically coal intensive and which does need that, but not only that one. We do need to make sure that we can be participants to this energy transition, especially also in light of the earlier discussions where it has been mentioned several times that Romania has a massive, massive renewable energy potential. And maybe this is our chance to actually fulfill this potential, since we have been hearing about this massive potential for quite a long time, for gas, for renewables right now. Maybe this is the chance to actually make it work. I think this is what I wanted to say now for the introduction.
There are a lot of insightful ideas. So what would be the biggest challenge at this point at the policy level?
I think yesterday there was also a discussion, a very nice one between Petra and Anna, talking about maybe, and I think personally that this biggest challenge can be, if you want, a misalignment between these initiatives at the level of the EU, because there are a lot. So every day you see something new, and maybe they're not all of them in line with the major goals. And if I can give just an example, a very punctual one. So in terms of ramp up of the hydrogen economy and a hydrogen framework, so the Commission says that by 2030 you need to produce internally 10 million tons of renewable hydrogen. Sorry, this renewable hydrogen is produced basically by splitting the molecules of water with the renewable electricity, which is produced either through wind or through solar. So they want us to do that. However, at the same time, they put in under the public consultation this document that sets some conditions for the producers of hydrogen, and that also refers to something called additionality principle, which basically means that you would be able to produce this renewable hydrogen only if your electrolyzer capacity has been commissioned with 36 months before the putting into operation of the power plant, and then also if the power plant has not been subsidized, which is quite, if you want, a little bit, in the industry, they say it can be a bit challenging to make sure that if we comply with these rules, then how do we manage to get to the 10 million tons of produced hydrogen internally? So this is just a punctual example of what is happening, and this document is actually under public consultation now. It will end on the 17th of June, so we will see afterwards what will actually be the outcome of this whole thing. There is another concept there, but it's a more technical one, which refers to the fact that you can only have your electrolyzing working while the power plant is working. So it will be this temporal correlation, which again is not necessarily very efficient and also not very good in terms of the hydrogen price for the future, and also for the lifetime of the electrolyzer, because then otherwise you have to keep it idle if the power plant doesn't work. So I think this was the one punctual example that I want to give in terms of misalignment, and this is what we have to actually be careful and to look out for in the future.
Thank you, Lavinia. I just want to quickly touch up on one point which you mentioned in terms of the energy transition, which is that we need backup plans and we need to be prepared for what can happen. So having that angle, I'd like to ask Thomas, in terms of disputes, what has happened so far, what have we learned from it, and what does the future look like in terms of climate change disputes?
Thank you. Let me start by saying thank you to the organizers and to our moderators and panelists for inviting me. I'm the only non-Romanian speaker on the panel, so I'm especially grateful to be included, and in that regard, let me say mulțumesc. Hopefully I've got some pronunciation correct. Speaking Russian might help a little bit with those aspects. Since we're coming... No, I know. But you do say da sometimes. Okay, so... anyone who is watching online doesn't realize that I am interacting very actively with the audience, but we'll focus our attention on the people here for now. Since we're coming at the end of this fantastic arbitration days, there are naturally going to be some elements of repetition in what you hear from us and from me, perhaps in particular. But what I'm hopeful to do is to maybe say things in a slightly different way and maybe even say one thing new. So let's see if we get to that. Thank you for the question. We've heard just now about the Repower initiative, and this comes obviously at this moment where we have Europe seeking independence from Russian fossil fuels in the broader context of transitioning to green energy. So what is happening now is we have major energy companies withdrawing from Russia. In response, Russia has taken a number of steps, including to impose these ruble payment requirements for gas supplies. But if we think about some of these developments as potentially helping the green transition, we have to remember that not all of it is going in that same direction. There are some steps that are going in the opposite direction. There's reduced energy supply at the moment, and as a result, some states are now turning back to coal-fired power stations, which are reopening. States are also resuming development of local gas fields. At the same time, there has been, we've heard from other panelists, inflation problems going on, and there's a particular crunch going on also from the current conflict. Plus, specifically to the metals markets, we have both of those issues relating to the region, but also commodity prices at record highs. And as we've also heard before, this has an ensuing impact on the possibility to develop renewable energy projects. So all of this is happening. We say that hopefully it leads to the green transition, but there are a number of obstacles that make that more complex. Each of those points that I've mentioned will naturally lead to disputes. And more directly, I would say first to commercial arbitrations. There are supply chain issues, contract terminations. People have been writing about this. There's a lot of commentary going on. Outside of the world of arbitration, quite recently before coming here, I noticed that a couple of traders have now launched claims against the London Metal Exchange. So really, this is starting to happen. And I would say in contrast to similar frustration type events that we've had in response to COVID, there's perhaps less of a goodwill moment going on. I think people will bring these claims. We were anticipating a wave of disputes arising from COVID, and it didn't quite come to fruition. Some claims, of course, did happen, but not the wave that we were anticipating. But I think in response to what's happening now, we will see more. We can compare those types of disputes that I've just mentioned relating to supply issues to disputes involving states. And I will turn to investment treaty arbitration eventually, and this is the point that I mentioned about something new, what I consider to be an important conceptual reframing. But before I turn to that, what I want to introduce first is this concept, and we've been hearing about this as well, the green litigation or the climate change litigation. So there have been lots of efforts by NGOs and climate change activists to hold governments to account. And a lot of those steps have been taken in the context of national courts. One such example is in the French courts, a trial that was referred to as the trial of the century. And it started in December 2018, where 4 environmental NGOs challenged the French government, arguing that it was not taking enough steps to fight climate change. The French government said that it was doing enough, that it was exceeding its climate change goals required under EU and other international agreements, but the court disagreed and ultimately found that it was not doing enough. So this is one of many proceedings launched against states in the courts in relation to climate change issues. And so what I propose is that we should consider similar claims by investors in the context of investment treaty claims in the same light. And what I have in mind in particular are the renewables claims. There have been numerous cases, just to recap, where states have been seeking to improve their renewable energy markets, introduce favorable regimes to attract investors, and later renege on their commitments. They don't keep their promises, and that leads to investor state claims. So what I propose is that we need to start looking at those claims as part of the climate change litigation family. There's been, and we heard some comments from the previous panel about environmental activists who are suspicious or issuing myths about the ECT. There's actually quite a bit more alignment that could be found within those groups with renewable investors. So that is my humble proposition. Just finally, to close, some states have been including environmental provisions at the treaty drafting stage or raising environmental counterclaims as part of disputes. And those steps we see as being supported by environmental activists. But what is lost is that the renewables investors have similar interests, their interests are aligned, and BIT claims should be similarly considered as part of that climate change litigation group of claims. Thank you.
Thank you, Thomas. Just to follow up here, Mate, what do you think in terms of different industries that might be impacted by these renewable claims that Thomas referred to that might be brought in the future?
So I just wanted to make one thought that I had when I was listening to Thomas. I think that the claims that we have and that relate to climate change and to the transition to greener energies can be in a way grouped into more or less three categories of claims. Those that arise from climatic changes and, for instance, extreme weather conditions, and that's a category perhaps not so novel, but I think it has been amplified more recently. And then you have those claims that are purely contractual in nature, that arise from technicalities or licensing, or from all kinds of aspects that are pure contractual. And then I think there you have the regulatory claims that I think Thomas briefly touched upon. And I think in all of those, you can see more and more claims and disputes arising throughout the sector. So both in the traditional or the conventional sources of energy, coal being one of them, where there you see claims that arise from states trying to take measures to phase out. Then you have, and obviously you have then disputes that arise from projects that are on the go or that are in bidding stage, and then the measures affect the investors' expectations. Then you have, for instance, and I think a good example of what I just said, the tripartite categorization that I made, is something that we've seen recently in a project in Southeast Asia that was the build of a hydropower plant. And there was an extreme weather event that caused one of the dams that were supporting the hydropower project to collapse. And obviously that caused an a big environmental issue. So there we had, and we are dealing with a number of claims. So we have claims from people affected by the dam collapse, and those are claims usually in the national courts. Then we have claims between the contractor and the owner of the plant that arise from, or that relate to invocation of force majeure events, the extreme weather event, or together with more technical claims dealing with the design aspects of the project. Then we see a claim from the investor in relation to measures taken by the state following the collapse of the dam, and essentially measures that were designed to limit the next stages of the project. And finally, you see down the line, if you want, claims between the owner or against the owner of the project and those who purchase power, which in that case is the state. So all of these being affected in a way by the extreme weather event that I just mentioned at the outset. Then in the solar, I mean, we discussed yesterday, there was a saga of cases arising from solar projects, Spain being the #1 example there. Wind, again, we've seen disputes arising out of new projects for wind energy developments, and we've seen that in Germany. And nuclear is, again, one of those areas where there has been a lot of tension globally as to how you categorize the nuclear sector and whether that is something that we need to move away from or not. And we have seen, again, claims that are of a regulatory nature, and then claims that are more contractual. Some of the world's most complex construction disputes are in the nuclear sector. And obviously then you have around those, if you want, you have more of financing claims, joint venture agreements, claims. So all of these, if you want, have one way or another a relationship with energy projects. Does that answer the question?
It does, but does that raise any questions from the public? We do welcome, if you have any questions or comments, feel free to just put your hand up and we can hand you a microphone if needed. All right.
Crystal clear.
Well, if not, we can move on to the second part of our panel, to climate change actions and going green. And I will move on to Krina. We also heard earlier about the ECT reform, and the clock is ticking on climate change policies. In your opinion, what's your view on the right to regulate new provisions addressing sustainable development, climate crisis in the modernized ECT, and how will these provisions impact the EU's position towards the ECT?
Thank you very much, and I would like to also thank the organizers for this excellent conference and for giving me the chance to meet again dear friends in person in Bucharest, my hometown. I think it's difficult to follow Graham and the rest on the Energy Charter Treaty, but I'll just add on the modernization process, something that perhaps we had to put it crystal clear, that is the process in itself is not transparent. Then you ask the question, but how do we know so much about it? Since it's not transparent, it's behind closed doors, because from time to time we do receive some leaked documents, and the latest one was not me personally. I'm not so well placed, but we have activists against the Energy Charter Treaty that are making sure to make this available. The last one was actually a consolidated version of the Energy Charter Treaty modernized in November 2021. And it is very interesting read. I suggest that perhaps when everything will be agreed in principle, we'll sit down and take a look and compare the versions. But for now, I think, given the fact that it's the focus is on climate change, I'm sure that some of you have read the press headlines such as multi-billion euro lawsuits derail climate action. EU urged to quit energy treaty as companies sue over climate action. Europe's Green Deal is under threat from the Energy Charter Treaty. So these are newspaper titles. And as Graham was saying earlier, there's the wrong impression that the Energy Charter Treaty is trying to prevent moving to the right direction. So I think there are three ways or areas in which the modernized Energy Charter Treaty is going to align itself, which is needed, with, first of all, with the 2019 EU Clean Energy Package, which indeed sets very ambitious goals by 2030 and 2040, and then a proposal for a fossil fuel non-proliferation treaty, which is on the table and which is endorsed by numerous cities, subnational governments, organizations, and individuals. And I urge you to Google this because it is a very interesting proposal. So there are three directions. The first one and the second already mentioned in the previous panels. The first one is the definition of investment under the Energy Charter Treaty. Something I wanted to add is that the EU proposal for the modification of the definition of investment is actually a phase-out, a gradual phase-out of the protection of fossil fuel energy. And it will much depend on the origin and also on the emissions. But by 2040, Part 3 of the Energy Charter Treaty will no longer apply to fossil fuel energy investments. On the second point, which is the right to regulate, already addressed, I think what is important to highlight is that I would say the position of the tribunals with respect to the right to regulate is not consistent. And this is one of the reasons why it is needed to have a provision dealing with the sovereign right to regulate, uncontested by tribunals, but what is contested is obviously the effects, as we could hear earlier. You regulate, you pay. Now, we do have very interesting cases now at the moment, already mentioned, before the ICSID, that relate to the phase-out of coal power by 2030 by the Dutch government. It is very interesting, and I wanted to highlight this. Different governments, they have different approaches. Germany, for example, managed to settle most of its cases. Even Ukraine had a successful mediation with respect to renewables. The Netherlands decided to go the other way, that is to confront the investors in the arbitration arena. But I think it's something that we have to keep an eye on. And what is important and was mentioned earlier, the right to regulate as the provision is drafted now in the modernized treaty is based on the experience from the arbitrations ongoing or concluded, and in particular the Spanish ones. Now, on the last point, on the third point, and the most important in my opinion, is the Energy Charter Treaty, the modernized version, at least the one from 2021 as it appears, includes binding provisions reflecting sustainable development goals and climate change. In fact, I would say that about 5 pages of the document are dedicated to numerous provisions on this issue. And it's difficult to summarize them all in 1 minute or two, but what is important, and something that was mentioned earlier with the reference to general principles, the international treaties, and so on, there is express wording detailing all the treaties, or at least the most important treaties or international obligations concerning environment in the Energy Charter Treaty modernized version. That is, the tribunals will have no problem in just turning the page and looking exactly what are the obligations of the states. The provision refers to the urgent need of pursuing the ultimate objective of the United Nations Framework Convention on Climate Change and the purpose and goals of the Paris Agreement in order to effectively combat climate change and its impacts, and that the parties shall effectively implement the United Nations framework and the Paris Agreement adopted thereunder and promote and facilitate trade and investment of relevance for climate change, mitigation, and adaptation. The most important part of this big chunk of provisions, I think, it's a very interesting and detailed provision concerning impact assessment. And I think lawyers will be very happy to hear this because that will give them more work. It basically says that each contracting party shall ensure in its legislation that an environmental impact assessment is carried out prior to granting authorization for a project for the production of an energy. And you'd say, but most of the countries would have this, correct? And we had several arbitration, in particular under NAFTA treaty, concerning exactly the point of impact assessment. But what is interesting is further explanation in the provision. The environmental impact assessment shall identify and assess as appropriate the significant effects of the project on population and human health, biodiversity, land, soil, water, air, and climate, cultural heritage, and landscape. And I think this last provision is very important for Romania in the context of Gabriel resources against Romania. Last but not least, also very important, each contracting party shall ensure in its legislation that an early and effective opportunity and an appropriate time period is given to the public concerned, including to the relevant non-governmental organizations, to participate in the environmental impact assessment, and an appropriate time period to provide comments on the environmental impact assessment report. And I think this is probably where the most important part of all these provisions on sustainable development and climate change, because one of the main criticisms of investment arbitration is that the societal interest is not reflected at the table. Of course, this reminds us of amici curiae participation, which is a separate provision in the proposed Energy Charter Treaty, but I think this will obviously help addressing all the concerns that we mentioned.
Do you expect a drop in the appetite for arbitrations if investors decide to turn to local courts for protection?
Well, I think the answer to this question has, well, we're talking about Komstroy, for example, and the ACMEA. I think it's not necessarily local courts. We need to make sure that whatever mechanism is put forward for type of disputes involving climate change and under the Energy Charter Treaty, it's adequate to the nature of the dispute. And I'll just give you a few points. Very interestingly, some of you don't know, but the arbitration chamber in Milan has a mediation process for environmental disputes, and it's actually very successful. So there are alternatives to traditionally courts and arbitration. Second, in the context of the Energy Charter Treaty, we have, as discussed, the Komstroy judgment, which some of us maybe read it quite quickly, perhaps not paying attention to the fact that the Court of Justice of the European Union said that Article 26(1)(c) of the Energy Charter Treaty, and that is specifically the part on arbitration, is incompatible with EU law. That means that access to local courts and to other agreed dispute resolution mechanisms is allowed. The last point is that courts, and to answer briefly to the question, courts are not prepared for disputes, to resolve disputes between investors and states based on international treaties. And it's not my opinion, it's what actually the courts are saying. We recently had the Veolia against Lithuania case. It's an ongoing ICSID case. It's an intra-EU, in which Lithuania did not bring a counterclaim in the ICSID proceedings. It did so because it said ACMEA judgment applies. It went to the local courts in Lithuania. The regional Vilnius court said, I don't have competence to hear the case. The Supreme Court of Lithuania said, no, you do have competence, and turned the case back to the regional court. A few days ago, the regional court of Vilnius said, this is a matter that involves acta iure imperi, the application of foreign public law, international law. RICA's Brussels regulation doesn't apply, so I cannot base or establish my jurisdiction based on that, and refer to the rules, the conflict of law rules of Lithuania, which says that the competent court is at the domicile of the defendant, which is France, because Veolia is a French company. The French courts probably will say the same thing. My point is that the local courts, they don't have the mechanism. Even if there is appetite, and I don't know if there is appetite of an investor to go before the local courts of the state that actually caused the harm, but the local courts are not yet prepared for this. So in the context of the Energy Charter Treaty, post-ACMEA, yes, it is an option. In reality, no, because the way the jurisdiction of the courts is constructed.
Thank you.
Thank you very much, Krina. Now that we talked about climate change disputes, about investment arbitration and the ECT, we would like to go to the second prong of the title of our panel, which is sustainability. And we heard from Lavinia about the macro framework in this regard from a regulatory perspective, but also what would be the small changes that all of us could implement to go green. And I would just like to explore what are the changes that we could do as lawyers and as arbitration practitioners to make arbitrations greener. Matej, Thomas, do you have any points here?
So I'm supposed to go to yeah, well, you stole my line. I think what I'll do is I'll start with some questions because I'm the speaker, so I can ask questions. So first of all, how many of you have heard of the campaign for greener arbitrations? Everyone.
Oh.
How many of you have heard about the Green Pledge? Everyone. How many of you have signed up to the Green Pledge? Fewer. Okay. How many of you have actually taken any actions that are consistent with the Green Pledge? Okay. Good. All right, so I'm not going to tell you what the... Excellent, that's it, I'm done. But it's interesting, and in your view, what do you think are the two most common things that we can implement in the context of an arbitration that would reduce carbon emission and would make the arbitration greener? Yep. Okay, and the second? I said two. Yes. So it's interesting because in a recent study, or actually survey, it was shown that a medium-sized arbitration, and please do not ask me to define what that means, but I assume it means none of those mega arbitrations that involve huge infrastructure projects, for instance, but also not a very simple contractual interpretation dispute. So in a medium-sized arbitration, having it run in a traditional way would essentially require planting or replanting approximately 20,000 trees. And that's a lot. That's more than I think any park in Bucharest has. And 93% of that is because of lights. And in a way, the pandemic helped with that because it showed that we can function very well and perhaps a bit more efficiently without actually having to travel to Mauritius for a hearing, although I still want to go to Mauritius for a hearing. But the point is there are better ways to do what we do efficiently. And one of them is avoid unnecessary travel. And that applies to arbitration proceedings. It also applies to events like this one. And I think it is amazing that we have the hybrid function that works really well. And I think that there will always be a human element that is required, and that's why an event in person is and remains great. And the same applies to an arbitration. There are issues, especially when you talk about examination of witnesses, that at least with the technology that we have today, it's difficult to see how it can be as efficient as in person. And there are things that even with additional technology, we may, I don't have a crystal ball, so I don't know what will come next, but it may be that there will remain things that are better done in person. So that's the flights. And we can take the train, if there is a train. And it's interesting because going back to more macro changes, for instance, in France, there is a proposal that any destination that you can reach from your city that is within 3 hours, there should be no more planes for that destination. Everything should be train. It will take a lot of time for anything to happen in that regard, but I think the point there is really that there is a change coming on that front. So the second point is obviously paper and going paperless. And I was very surprised to find recently that for instance, and this is not arbitration, this is international litigation if you want, in ICJ proceedings, do you know how many copies of written pleadings do you have to submit together with all the evidence? 125, yeah. So every submission in every case needs to be filed in 125 copies together with all the exhibits printed in the same number of copies. There is a proviso there. So if you want to be greener, you can file 75 copies and distribute 50 USB drives. Now, I really do not understand why you need physical drives instead of uploading everything on a platform, but there you go. And there are trucks that sometimes go with all of these tons of papers that probably you can use and build a house with. So there's the paper point, and I think that brings me to the campaign for greener arbitration and to the pledge. And beyond the obvious point that we should all take measures that reduce energy consumption, correspond electronically, use video conferencing facilities and all of that, I think that what the green arbitration campaign is doing is proposing a set of protocols to be used by the different actors in the arbitration profession. And that includes one, I think, which is one of the protocols that I find most useful, at least to date, is a proposal for a procedural order that adopts some, or parties can adopt some of the greener practices that are being advocated by the pledge. And I don't know if any of you have used the procedural order, the green order, in an arbitration that you've been involved. Yes. As counsel? Yes. Twice. Okay. Adapted or adopted in full? Okay. Anyone else? Sorry. Small claim, though. Small claim, not medium size. No. Okay. Okay. Yeah. So I think I mean, and that's one way of. And I think there was a recent Queen Mary study that showed that yes, respondents agree that greener practices are what we need to aspire towards, but they are not a priority in and of itself. It's, however, if you want, the side effect of becoming more aware of the need to be efficient. And so I found that, and I think that we will get to a stage, and a lot of it rests with the users of the arbitration community, counsel, arbitrators, and parties, and the institutions. But I think it will come to a stage where, so for instance, I was involved recently in an arbitration as an arbitrator, and I was presiding arbitrator, and I proposed the protocol, and the parties got scared. They're like, why do we need all of this? And the way I managed to make use of it is by saying, well, does it affect you negatively in any way? And the answer to that was, well, we don't know. We need to take instructions on that. We did include some of the things, and obviously there are limitations to how far you can go, because we can very well say everything is paperless, we don't need signatures, everything is electronically done, but there may be places in the world where that doesn't work. For instance, a witness statement needs to be signed by the person. You can't put an electronic signature in some jurisdictions. In some jurisdictions, when you want to examine a witness, you cannot do it by video conference. You need to have it in person. Some jurisdictions require arbitrators to sign the award physically at the place of arbitration. So there we go, we have 3 people flying from various parts of the world to a lovely destination, meet in the airport, sign the award, courier the award, and then fly back. It's great, right? It's.
The Dubai is one that is requiring you to be present in the chamber, signing in front of one of their staff, authorized staff.
So it used to be, okay. All right, let me put a disclaimer. So there are a number of, and as I said, I said a number of jurisdictions, not everywhere. There are the number of jurisdictions in the Middle East that are still evolving in terms of what the practices are. And yes, there have been legislative reforms modernizing the arbitration laws in most of those jurisdictions. The laws are, I would say, most of them now ancestral based and quite clear. The practices are a bit different. And what I mean by practices is that once you have your award, you sign it and you want to enforce it and you go to the local courts to enforce it, you may find that some formalities have not been complied with, and then for your award is essentially not even worth the paper it's written on. So I think all of these are things that should change and need to change. And with that, I think that's, yes.
Sorry, just 1 second. Could we just get you a microphone maybe? Because if you don't have a microphone, I don't think people who are online can hear you. Yes, yeah, thank you.
So,
replace paper with technology. You know we use about 118 rare metals to produce computers, optical fiber, mobile phones. They are not economically mined. In order for that to happen, it is a huge other operation which does not fit under any of the renewables or, you know, clean procedures. How do you deal with that?
Great. I mean, I think I will start, but that's a very good point. I think a lot of that, I think the simple point there is how often you change that technology. Because if you have your the same screens and laptops and you use them in 100 hearings, then that is definitely better than going paper. If you do always want to have the newest iPhone, I suggest that is the bigger problem.
Remember that the current market, it is not anymore 10 years durability. It is use and throw as much as possible. So that's not helping.
I haven't changed my iPhone in 6 years. It doesn't work anymore.
I haven't changed my laptop in 12 because I love it and it's very good, but.
Yeah, no, but that is a very good point. But that goes, in a way, that goes beyond what we can do in terms of embracing new technology. It's a bit of the way the market and consumer market operates. And I agree with you that the tendency is not particularly green. Questions? Yes.
Thank you very much for your very insightful presentations. My question is not on the substance of your presentation, but rather refers to the practical aspect of it, considering that many in the room are lawyers and also many watching us are young lawyers. I would like to ask you to share your opinion whether this new field of interest, namely climate change and sustainability disputes, represents already or will represent in the near future a new specialty for lawyers, for arbitrators, for experts, so a new field to work in for the younger generation. Thank you.
I just wanted to say from my my experience as a professor that at least 2 students are writing a master thesis on a topic related to climate change. This reminds me of mediation a few years ago, and here we are with mediation. We have the Singapore Convention. So I think the first step is to educate and raise awareness. And the fact that the new generation, the young generation of practitioners shows interest in it means that in the future there will be a need for it and specialized lawyers working or professionals. The other point is that we have a very good example from inside our profession. Some of you might be familiar with the SSC, the Arbitration Institute, in Stockholm, and a few years ago, the SSC had the initiative of drafting a treaty related to climate change, and the Secretary General then, Annette Magnusson, she left 1 year ago, 1.5 years, and she established a think tank which is called Climate Change Council. I'm mentioning this because from our profession you see these developments, but more importantly, the Climate Change Council won the GAR Award this year for, I believe, for innovation. It was a paper mapping the Energy Charter Treaty cases, disputes dealing with climate change issues, and I recommend it's available on the website of Climate Change Council. It is an excellent paper that would advance, and I hope it advanced the discussions in the ECT modernization group. So absolutely.
If I can just chime in on that point, a number of anecdotal points which I think confirm your question that yes, it is moving into a specialized area. More than 60% of the ECT claims relate to the renewables industry. Already there's that. I have, from my own experience, to echo what Karina said about students focusing on this issue. Before launching my own practice, I worked in 2 of the most prominent arbitration practices in the world, both of which have had associates from the arbitration team leave and join environmental NGOs, where now they focus on climate change litigation. At the same time, we've heard from the preceding panel of members of the arbitration community that exclusively now do renewables claims as part of investment treaty claims. So yes, more and more, I think we are seeing this.
Good afternoon. My name is Katerina. My question is probably addressed to everyone on the panel, depending on who would like to answer. And it is related less to sustainability and more to environment and environment-related disputes. So we've heard throughout these 2 days that we have a lot of alternative dispute resolution mechanisms. And my question is, how do we go about claims raised in response to environmental damage that was brought about by military actions, in particular invasion? So what we are witnessing right now on what we witnessed before, for example, when Iraq invaded Kuwait. So my question is, what is the best and most effective dispute resolution mechanism to resort to for the parties, whoever they are, investors or states or private parties who have small businesses on the land that was affected? Because we know sometimes we are talking about lots of important issues here. Damages. Some respondents do not even appear in the ICJ, as we witnessed a couple of months ago. So what's the most effective way to go about that?
I think the answer depends on what is available at the international level, what remedies would be. When you're, it's not related to obviously tragic events as we are witnessing today, the war, but we see, and this was addressed already, increasing litigations against companies, first of all, and states. Either because they failed to meet their commitments or companies. And one example is the 2015 litigation before the German courts against RWE that I mentioned, the same company that is involved in a exit case. And this was brought by a Peruvian farmer for the environmental damages caused in the area of his farm in Peru, this is one, and very interestingly, the judges in Germany, they had to go conduct a assessment. Obviously, we have this. They had to go to Peru to experience themselves the damages caused to the environment. So I think what we see, again, it depends on the available remedies. In treaties before the local courts, it depends on the local courts as well. So that would be an example that comes closer to this scenario.
Just to add on that, I think, I'm not going to start again with it depends, but if you look at what happened in the past, I think one of the key questions is who is going to pay for where you are going to get your damages claims from. And I think that you've seen for instance, in the Iran-US claims tribunal, how that worked. We've seen that in the Eritrea-Ethiopia tribunal, how that worked. And I think and it's easy to say, okay, well, we'll just create a tribunal, a special tribunal dealing with the issue. The problem is there needs to be a way to essentially to be able to repay the victims or the claimants, essentially. And so I think there is a question of, and it's not an easy question, but there's a question of finding the right, and probably special tribunals is what worked in the past, and I suggest they can work in the future, and in the particular case that you probably are thinking of. But it will be a question of making sure that you have a pot from which you can recover damages. And so, and the difficulty in the example that I think you're thinking of is, in all of the past examples I gave, there was, in practice, there was a victor and there was a losing side in each of those conflicts. And so I think that, and that is probably what helped with having the claims tribunal set up and work in practice. I mean, if you don't get to that phase, it will be very difficult.
We promised that this would be a very lively panel, and I think we have fulfilled our promise. But being mindful of time, we will take one more question.
Thank you, Katerina. I have two, but you know, choose the one that you prefer. One is more practical, is related to the modernization of the European Charter Treaty, and we discussed about the national court efficiency for this type of claims. Jaime, I would like to ask the panelists, where do they see fit the multilateral investment court within this framework? And the second question relates to the fact that we see climate change as a sort of a more diffuse type of damage brought to the civil society. And in this respect, would you foresee in the future, under this type of claims, the civil society more engaged as claimant against states? You know, Thomas was mentioning the fact that some of his colleagues went to litigation, but I would say that probably also arbitration should have its own path in this direction. Thank you.
I may just ask a question which is similar, whether we're going to see other counterclaims from the state against the parties in the future.
Go for it. Go for it.
On the Energy Charter Treaty and the Multilateral Investment Court, let me put it this way. The MIC is on the agenda of the European Union, and it will be implemented. That's a fact. If this is going to be the only option, that's something that we have to see. In the context of the modernization of the Energy Charter Treaty, Article 26 is not on the table. So probably, I hope so, will not have a surprise, but will not see, for example, arbitration institutions removed from Article 26, and certainly nothing added to Article 26 as it is. This doesn't mean that separately there may be a provision addressing future developments as the MIC or a disconnection clause or whatever it's on the agenda of the European Union. But it's something that will be in the future. The UNCITRAL Working Group 3 should conclude its mandate in 2027 with a bit of luck. And at this moment, actually as we speak, this last 3 days, there was an informal session discussing a specific issue related to the Multilateral Investment Court, which is the appointment of judges. So you can imagine that the road to actually have the institution shaped as it is, and more importantly, how it's going to be implemented in the existing treaty framework and in the future treaty framework is still to be discussed. And actually this latter point on the implementation is the most difficult one. One proposal is a Mauritius Convention type of tool, but it is very difficult to say at this point. So I would just answer this part.
I'll briefly touch on the second point, which is, I'm going to reframe the way that the question was formed, which is investment treaty arbitration the proper venue for environmental claims to be aired? And I think whoever answers that reveals their philosophical approach to that. And this is actually a topic that among the panel we discussed in preparation for this. So I won't necessarily jump the gun and give you my answer, but to answer the second additional question, I think we will see more of these as counterclaims, if for no other reason, purely as a guerrilla tactic. Yeah.
But on the counterclaims, I think it much depends what the treaty gives you. So if the Energy Charter Treaty modernized as it is now, some provisions they have teeth and they could possibly give rise to counterclaims. But let's remember, most of the treaties, they do not have this. I think that's important.
And if I can say something, not from the perspective of an arbitration specialist, because I'm not one, but looking at the regulation and considering that climate change includes renewable energy disputes and all that, and how we see all these sorts of new structures coming up, energy communities, hydrogen valleys, prosumers, this and that. I think you guys will have a lot of work to do because I can imagine there will be a lot of disputes in this area quite soon.
So, if there are no more questions and no final remarks, we would like to kindly thank you, our speakers for their insightful ideas, to thank the organizers for this fantastic organization of this edition, and also to the audience present and virtually for their patience to hear us in these 2 days. I hope you all enjoyed, and see you later. Thank you. Yes.